Good morning. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, Courtroom 304. This is the jail calendar, probation, revocation calendar, and mini arraignment calendar for July 15th, 2025. I'm going to call the calendar. If you're represented by an attorney, your attorney is going to speak on your behalf. If you're here, I do need to know that you're here. And if you're not represented by an attorney, we'll be speaking directly with you and we'll explain some things to you about this process. All right, so the first name on the calendar for arraignment is Jayla Douglas. I do not have an attorney for Miss Douglas. Jayla Douglas.
Miss Douglas present in the courtroom? Come on up, Miss Douglas. If the judge calls your name, stand up and walk up to the podium. Up here, all the way up here.
Miss Douglas, good morning. So, Ms. Douglas, you're charged with speeding 21 to 25 miles per hour over the limit and distracted driving. Do you have an attorney representing you, or do you wish to represent yourself or have the court appoint an attorney?
I don't have an attorney. I guess I can represent myself.
How old are you, ma'am?
18.
So let me just give you a little bit of information before you choose to represent yourself. As an under 21 driver, it only takes 4 points on your license to get a suspension of your license. You would not be able to get a permit for school or work. So it means that for 6 months, you would not be able to drive at all. Did you wish the court to appoint an attorney to assist you?
Yes.
All right. So Mr. Lynch, Ms. Tortorello, I'm going to appoint Ms. Douglas. So the attorneys in the courtroom are going to speak with you about your case, okay? All right, have a seat for me. Donovan Ellis. Donovan Ellis is on video. Donovan Ellis.
I'm here, sorry.
All right, so Mr. Ellis, I do not see an attorney. Do you have an attorney representing you?
No, ma'am.
All right. Did you wish to have me appoint an attorney, or did you wish to have to represent yourself? You're charged. Okay, you're charged with no insurance and following too close. So, sir, are you over the age of 21?
Yes, ma'am.
All right, Mr. Ellis, if you move your computer down a little bit, because all I see is the top of your head. There you go. Thank you.
Yes,
all right. So, Mr. Ellis, I'm going to hear from the state and figure out what they are proposing for a sentence in this case if you were to take a plea. Mr. Tipton?
Your Honor, we would suspend all fines and just ask that Mr. Ellis pay restitution on the following too close. It would be restitution in the amount of $550. That is for the deductible of the victim. The no insurance, he qualifies for a NOLO on the no insurance. He does not, he would not receive any benefit from a NOLO on the following too closely, though, because he's pled to that. He pled NOLO to that in 2022.
Gotcha. Yeah, I have the documentation to send over that I had insurance at the time. The officer said he had another call to make it too, so he wasn't able to hang around, obviously, that he had to tow my vehicle. But he believed I had insurance. I just wasn't able to prove it in time.
Do you have that information now?
With me? No, ma'am. I could get it, though. Is there any way I could, like, scan it over or email a document?
Well, sir, yeah, if you got it, but
I can get it. I don't have it accessible to me.
This is the time to
Yes,
have.
ma'am. Yes, ma'am. I have it in text message form. I just don't have like paper copies of it, or I have photos of it.
Your Honor, state's
Okay.
just state's going to, it's an old case. State's just going to dismiss the no insurance if he'll pay the restitution and plead to the following too close.
Gotcha. I can do that.
All right, so now you understand that your option for pleading to a following too close would be a guilty plea because you've already used the NOLO on that.
Yes, ma'am. So I would just pay the restitution fee, right?
Yes.
Yes,
now,
ma'am.
and I'll give you 12 months probation to pay the restitution. And then as soon as you pay the restitution, the probation will terminate.
Yes, ma'am. So how would I go about paying that? Who do I pay that to?
Okay,
The
you
court or
would pay it through probation.
Mhm.
They would forward it to the person who is receiving the restitution, and once they confirm that it's all been paid, then your probation will end.
Got you. Do I come up and do that in person or can I do it online?
They can explain it to you. I'm gonna put you in a breakout room once we take your plea with the probation expert, Ms. James. She's
Yes.
gonna explain how they will receive the probation the restitution through probation. I don't know if they have an online portal, but I know you can always come up and pay on the second floor at 9151 Terra Boulevard.
Yes, ma'am.
All right, are you ready to take your plea, sir?
Yes, ma'am.
All right, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. So, Mr. Ellis, you're before the court on 2023 CR 00205, Donovan Ellis, for no insurance, and following too close, the no insurance has been no pros. The following too close, you're entering a plea of guilty. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. Ellis, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right. Factual basis recommendation, Mr. Tipton.
Yes, Your Honor. On May the 11th of 2022, officers with the Clayton County Police Department responded to a vehicle accident on Terra Boulevard near the intersection with Village Lane. There it was determined that the defendant before you, Mr. Donovan Ellis, did drive too closely behind two other vehicles and cause a three-car accident when he rear-ended a vehicle in front of him. Your Honor, the state's recommendation is for count 2, a restitution in the amount of $550 to be paid to Dericka, D-E-R-I-C-K-A, Gale, G-A-L-E. I will provide the address to the clerk and probation for the restitution to be paid.
All right, that's perfect. Thank you. So, Mr. Ellis, I'm going to accept your plea of guilty to count 2. Count 1 will be no pros. I'll sentence you to 12 months pay only probation for you to pay restitution in the amount of $550 to Dericka Gale. Upon payment of that, your probation will terminate. Okay.
Yes, ma'am.
All right, so I'm going to put you in a breakout room with Ms. James. Ms. James is our probation expert. She's going to explain everything that you need to do. Just go ahead and get this done as quickly as you can. And once you do, you will be free of all of this, okay?
Yes, ma'am. Thank you so much. I appreciate it.
All right, thank you, sir. So I'm going to put you in breakout room number 6. You'll see an invitation to the breakout room pop up on your screen. Once you're finished speaking with Ms. James, you do not have to come back to the main room. You're free to go and just complete the restitution payment, okay?
Yes, ma'am.
All right, be safe out there, Mr.
You as well. Thank you. Have a good one.
All right, next is Rashan Gwyn. Rashan Gwyn. Last call for Rashan Lamar Gwyn.
Mr. Gwyn.
Oh, there we are. Hi, Mr. Gwyn.
Hello, how you doing?
I'm good. So, Mr. Gwyn, do you have an attorney representing you?
No, ma'am.
All right. Did you wish to represent yourself, or did you need an attorney appointed to you?
I probably need an attorney appointed to me because I'm
All
not sure of this ticket.
So, Mr. Gwyn, you're charged with speeding 31 to 34 miles per hour over the limit. I'll appoint Mr. Lynch or Ms. Tortorello to assist you, and they will speak to you about your case, okay?
Okay,
All right. Thank you.
thank you.
All right. Next is Olandras Hill. Olandras Hill. Mr. Holton Dennis.
Hi, hello. Yes, I'm here.
Hill. Okay.
Your Honor, both Solicitor Holt and Dennis attorneys have stepped out. If you may give me one moment, I will retrieve one.
Well, how they step out in the middle of the call of the calendar? All right. No, that wasn't for you, Mr. Tipton. I'm just fussing. All right, ladies and gentlemen, it is very helpful to me if you put your first name and last name on the screen, a nickname, your phone designation, one name. Those don't help me because I don't know where you're supposed to be if you can't unmute or let me know that you're here, okay? So you could get a bench warrant just by a failure of technology. So it is better if you can put your first and last name on the screen for me. All right, so Mr. Lynch, Olandras Hill.
Is Ms. Hill present on the Zoom call?
She is.
Yes, I'm right here.
And my understanding was continued for PTI status. Is Ms. Hill currently enrolled in PTI?
You said,
Miss
am I currently
Hill.
enrolled into PTSI?
The PTI program.
No, I don't know what that is. I'm not sure what it is.
Okay, did someone send you information about enrolling in the deferred?
I'm sorry, I misspoke. It said PTS calendar.
Oh, okay.
If we could just have a brief conference with Ms. Hill, Judge, and I'll see if we can get
All right, so Ms. Hill, Mr. Lynch is going to reach out to you. He will probably either call you or ask to be put into a breakout room with you later. So just mute your device so that we don't hear any part of your conversation with your attorney, okay?
Yes, ma'am. Thank you.
All right, thank you.
If you could put in the chat to courtroom 304 a number where I can reach you, that might expedite the process.
You might want to send her, send her. So Miss Hill, you're looking for a red box with a white number in it. You're going to respond to that and send Mr. Lynch your information, okay?
Yes, ma'am.
Thank you.
Thank you.
All right. So next is Tazaria Hugley. Tazaria Hugley.
Your Honor, if I may.
All right, Ms. Hugley's here. Ms. Hugley, you're charged with speeding 26 to 30 miles per hour over the limit. Did you wish to have an attorney represent you, or do you have an attorney?
No, I don't have an attorney.
Okay, did you wish to represent yourself or have one appointed?
I'll represent myself because I had court a couple weeks ago, and they told me to go take a driving defense class, and then they put me on this court calendar. So I took the driving defense class yesterday.
Okay.
I mean defensive driving class.
I got you. Do you have the paperwork?
Yes, it's on my email, and she sent me an email basically saying that hold on, wait, I'm trying to pull it up on my other phone. But she sent me an email saying that I'll have the actual certificate by the end of the day. See, I don't know if you can see, but it's the email right here.
Okay. Mr. Tipton, what do you want to do with this? You want to wait and put it on for a later calendar?
Your Honor, I'll go ahead and make an offer with the defensive driving amount, with the defensive driving class taken into account. I'll go ahead and give her credit for that. At this point, just a $500 fine would be what the state would be asking for.
Is she NOLO eligible?
Yes, Your Honor. Yes.
All right. So Ms. Hugley, the speed is 26 to 30 miles per hour over the limit. Mr. Tipton said that he'd be willing to take the defensive driving course into account, and that the fine would be $500. You are NOLO eligible, which would help you avoid points on your license or suspension of your license. The regular, if I'm not mistaken, the regular sentence that they ask for from the state for this type of offense is 12 months probation, a fine in the amount of $500, a defensive driving course, termination upon completion. So you've done the defensive driving course. he's willing to take that into account if you wish to take a plea.
Okay, that's fine. And then I'll do the no load for the no points on my license. And
Okay,
then I can pay the fine. I'm not trying to be on probation for a $500 ticket.
okay, so let me just, in all candor, I like to tell people the total amount with the surcharges is going to be $737.50. I can give you up to 60 days to pay without putting you on probation. Would that be
Okay.
sufficient?
Okay, yeah, I'll do that.
All right. So raise your right hand for me.
Hold on.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down, ma'am. So you're before the court on 2022 CR 07730 for Tazaria Hugley. Am I pronouncing your name properly?
Yes.
All right. So you're entering a plea of nolo to speeding 26 to 30 miles per hour over the limit. By doing so, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right, factual basis recommendation, please.
Yes, Your Honor. On August 2nd of 2022, officers with the Georgia Department of Public Safety, while using a pro laser speed detection device, did pull over a vehicle that was driven by the defendant, Miss Hugley, that being a white Ford Mustang 2021, that they had clocked doing 93 and a 65. Miss Hugley has had a 21, a 95 and a 65 from 2019, and has subsequently had a 64 and a 45 in 2023. State's recommendation is a $500 fine. We are not requiring a defensive driving course because she has done that prior to court today.
All right. So Ms. Hugley, I'm going to accept your plea. The fine is $500, $737.50 with the surcharges. I'm going to ask you, do you know how to use the chat function?
Yes.
Okay, so I'm going to ask you, you go to the chat function, there'll be a name in blue, click on that, so you'll see the little arrow, click on that, and then when the menu comes down, we're looking for Amanda Wright, R-Y-T-E. I need you to send her your email address, make sure you check it for everything being in the right place before you hit send. She's going to send you your sentencing sheet that has all of the information on it that you'll need to pay online, by phone, or in person. Also, it will tell you the date by which this needs to be paid. Okay, and you want to make sure you pay by that deadline or an arrest warrant could issue.
Okay.
All right. So, Miss Hugley, let me just holler at you for a minute, just girl to girl. I like fast cars too.
Yeah.
I used to have a Mustang. But
Mhm.
I'm just gonna say, at a certain point, we gotta outgrow that test the car thing, and you slow down. All right.
Okay.
All right. We don't want you to have an accident or hurt somebody else. Okay.
All right.
All right. Thank you.
All right.
My first fast car was an IROC Z. You wouldn't remember nothing about that. You're too young. But all right. Slow down for me, Miss Hugley.
I
Once
will.
you send that information to Miss Wright, you're free to go.
Okay, thank you.
All right. Take care.
Mm-hmm.
All right. So Thomas Lewis.
Your Honor, I believe one of Mr. Lewis's brother is on the call. Mr. Lewis, we did do a consent order for a unsecured judicial release to release him back to a group home or to a new home. And so he is currently there at the same group home. I had an issue getting him the ability to appear today. So I was gonna, so that's why his brother is on the call at this point, Judge. I would ask for maybe one more reset to determine if there's any resolution we can come to.
Your Honor, the state would be fine with a reset. State's very familiar with Mr. Lewis's case. I do believe it's the defense's intention to file mental health evaluation. And the state has no issue with the reset of up to 90 days.
Okay. Ms. Val, if you could get me a date that works for Mr. Lewis, if we contemplate an MHE, and we're gonna need some time. Just give me one moment.
Can I be heard? Am I?
1 second, sir. I'll be right back.
I don't understand what's going on. He's not in no situation where he can be on probation or none of that stuff. And most help y'all can offer him, you would almost already given him.
Sir, you're not muted. Please hold off on top.
Oh, I can't be.
Please, you're not muted, sir. Please hold off for just a second, okay? Thank you.
All right, sir. You were speaking. First, tell me your name.
My name is Kevin Lewis. I'm Tommy Lewis' brother.
All right. So Ms. Lewis, Mr. Lewis is represented by counsel. They asked previously for a continuance to allow, they asked previously to allow him to be released from jail so that he could go back to the group home that he was supposed to be living in. And my understanding is that Mr. Lynch, his attorney, wasn't able to get him on video today for court or get him to court from the group home. So what they're asking for is a reset for another date and possibly an evaluation for Mr. Lewis. Now, how can I help you?
I was trying to figure out like where are they going because I was the one that picked them up. And I'm also the one that helped put them in the last two group homes. He's not currently able to go to the last group home due to the policies of DCH and, you know, how they handle the intake, whatever. He's
Well,
at
where
a
is
new
he? He's at a new one?
Yes, ma'am. And he's actually back on his medication. He's seeing a doctor. I'm not actually sure what was going on at the last group home, but it was to my understanding, he wasn't really getting his medication. My brother has a traumatic brain injury.
I got
So
you.
I'm not really sure about where they're trying to go with this case. Like he's not in a situation where he can deal with probation and things
I got
like
you. Sir, I'm very, very aware of like the limitations of like how far people can go with probation and things like that. So I will generally ask, like, is this person able to do probation? Would they have transportation? Would they have the money? Would they have the ability to do the classes? So we generally will ask those questions. Because, you know, Mr. Lewis has been before me at least once before, I kind of have a sense of what's going on. So I don't put on people more than they are able to do. What I would ask is, Mr. Lynch, do you have his new placement and all of that information?
I do know where he is, Judge, but as far as like a direct contact number, but I do have Mr.
he has his own phone. He has his own number and all that. I set that up for him as soon as he got up. So
Okay,
I mean, he's able to be contact. But my brother, he has short-term memory loss.
I got you. And see, so that's why sometimes it's helpful to have someone at the group home who can work as a liaison, because I don't want your brother to like maybe have an appointment to come to court and then not remember or set an alarm for himself. So that's somebody who could help him. So what I'm going to ask is, do you know how to use the chat function?
Judge, I'm just going to text Mr. Lewis. I have his phone.
Okay, so Mr. Lewis, Mr. Lynch is going to text you. If you can help him to keep in touch with your brother, that would be wonderful. We know kind of what your brother's going through, so we're not asking him to do something that it would be impossible for him to do.
And also, as far as like the mental health evaluation, he just seen the nurse last week. So I think
if that information, well, we don't go through the DBHDB if we don't have to, because it takes a long time. So if he has a current evaluation, and we can get his attorney can have access to that for him. So that's a process. Mr. Lynch will kind of walk you through what that takes. But if that's present and something that has been done recently, that would be helpful as opposed to kind of having him to wait for the availability of an evaluator through the state. Okay, so Mr. Lynch is gonna text you. He's gonna reach out to you. And then if you would provide Mr. Lynch the information and kind of stay in contact with him, then we'll work with you to make sure that we do what's best for your brother.
All right, thank you.
Okay, I understand the group home situation. Sometimes Mr. Lewis can't even communicate the whole breadth of what's going on in group homes. And so I have some understanding of how, things like if the meds aren't given or, they're not in a group home with people who are compatible. I get it. So,
truth be told, my brother has been mentally challenged since birth. And then him being in this car accident and the traumatic brain injury, he had 4 surgeries on the brain. It didn't make it no better. You're talking to a 35-year-old man that's 3 sometimes and maybe 10 the next time, and then he don't know who he is or who he's talking to the next minute.
I got you.
He can't. He can only do the best he can as far as the ones he depend on. So if the ones he depend on is not doing what they're supposed to do, then it's only so much fault he can take. But I'm not trying to take, the accountability.
No, I get it completely. Thank you for supporting him, because a lot of times families get what we call caretaker fatigue, and they get tired because they have to do so much.
That's my little brother. I've been knowing since I was young I was gonna have to take care of him, and I got my own struggles and stuff. But
well, thank you for being there for him. So Mr. Lynch is going to reach out to you, and then y'all can kind of help each other work something out that is acceptable. Okay.
Yes, ma'am.
All right. Thank you. Thank you, Mr. Lewis, for coming in.
Thank you.
All right.
Does you still want the 90-day date?
Yeah, I do. We may not need it, but let's go ahead and do it. And if Mr. Lynch needs to update us and come back sooner, we'll do that.
Okay, it's 10/21.
Okay, so October 21st, 10 a.m., Ms. Val?
Yes, ma'am.
Okay. All right. And then
I'll make sure he's present as well.
All right. And Mr. Lewis, Mr. Lynch will let you know if something happens and y'all need to come back quicker than that. That's fine. We can work that out. Okay.
Yes, ma'am.
All right. Take care, sir.
All right, you too. Thank you.
Dana Lauren Talley. That's Mr. Gabriel Winter's case.
Yes, ma'am.
Good morning, Your Honor.
Good morning.
Your Honor.
Yes.
Pretrial division, looks been to a pretrial in August. Just to update the court on this.
I'm sorry, I missed half of what you said. It's glitching. So tell me again.
Your Honor, that case is scheduled. That case is currently in pretrial diversion.
Okay.
However, it appears that for whatever reason, Ms. Talley could not make it to the most recent pretrial orientation. So we have rescheduled her for the 12th of next month.
Okay. So we'll check in on her in September or October.
Your Honor, we spoke to Ms. Ponder and she said she was considering it for diversion, but we never received notice that she was actually accepted into diversion.
She's been accepted, Mr. Tipton?
Your Honor, and I apologize to Mr. Winters for him not receiving that information, but my understanding is she was previously accepted into diversion and was scheduled for it. I will get with Ms. Menard Knox and I'll make sure that he has good contact information for Mr. Winters from there.
Okay. So Mr. Winters, Mr. Tipton's going to go ahead and follow up with the director of the program, Ms. Menard Knox, and then he'll get back to you. But his understanding is she has in fact been accepted to the program and will be starting on the 12th of next month.
August 12th, got it.
Yes.
Now she does live in Tennessee. Can she do that virtually?
I have no clue. But that's something that Mr. Tipton and Ms. Menard Knox will work out.
Okay. Thank you, Your Honor.
If she's been accepted, I would assume they know she lives in Tennessee because usually they do an intake.
Yes, Your Honor.
All right, then. So
May we be excused?
Yes, sir. Keep in touch with Mr. Tipton.
Thank you, Your Honor.
Thank you.
Next is Jamantre Taylor. Jamantre Taylor.
He is on the calendar. I know that it notes continue for PTI status. However, from speaking to Mr. Taylor financially, he doesn't think he's going to be able to do. And so I'm talking to an alternative recommendation. I'm hoping we're going to get that resolved today.
All right, so I'll put you down for a conference. And Shamar Thorp. Shamar Thorp.
Yes, Your Honor.
All right, Mr. Thorpe. Mr. Holton Dennis?
Yes, Your Honor. I understand that my client was placed on the calendar for a follow-up for PTI.
Yes. Mr. Thorpe, have you completed your PTI?
No, no, ma'am.
Did you start it?
No, I don't think I did.
Your
You
Honor,
would know, yes.
Your Honor, I have that he was scheduled and failed to appear at pretrial diversion. He was scheduled for May 13th of 2024, was noticed and did not appear.
Mr. Thorpe, what happened?
What he just said?
He said that they sent you notice in May to appear for your pretrial orientation and you didn't appear.
I didn't get no notice in May.
Maybe they don't have his correct address.
Okay, that is possible. So Ms. Tortorello, if you will conference with Mr. Thorpe and see if y'all can work that out.
Yes.
All right, so Mr. Thorpe, just stay on. Ms. Tortorello is going to speak with you and try and figure out what happened and see if we can save you. Mr. Tortorello, also please make sure he knows about the fine, the cost of the program in case that would be an impediment also. All right. All right, so ladies and gentlemen, that completes the call of the arraignment calendar for July 15. Here's what we have. Douglas has been appointed. Ellis is a plea. Gwyn has been appointed. Hill is a conference. Hugley is a plea. Lewis is a reset. Tally is a status check. And that status check has been complete. Taylor is a conference and Thorp is a conference. All right. And when you all have announcements on the arraignment calendar, please let me know. The jail calendar. All right. First name on the jail calendar is Robert Barnes. Robert Barnes. In this case, it's been reset a few times.
Your Honor, just to make an announcement on my client, the evaluation order was filed on June 10th, and we did provide all that information to the Sheriff's Office on June 12th. So the Sheriff's Office is aware of the filing order, and that's all of the updates that I have at this time regarding his matter.
And this is for Mr. Barnes?
Yes.
I'm sorry, I'm not understanding. So you said the sheriff, there was a...
We filed an evaluation order.
Oh, okay, that's the part I missed. All right.
On June,
And it hasn't happened yet?
we advised the Sheriff's Office of it already. We've sent the Sheriff's Office the information. The DBHDD does the eval, so I'm not quite certain at what stage he's at right now, whether he's still waiting to be evaluated or he's already been released to be evaluated.
All right, so you need a reset to?
30 days, Your Honor.
All right. All right, Ms. Val, if you'll give us a reset 30 days out for me. All right, next is Jamal Tayun Brown.
Judge, that's my client. So I believe maybe some of his family members are on the call.
We are.
So I did contact the jail to try to make sure that he was properly medicated. I was hoping to get his case resolved today, Judge, but it's a possibility that I'll have to file an order in this case based on my interaction today. However, I'm going to try to follow up with him. I know that Mr. Brown has been offered essentially credit for time served. However, at this point, I cannot
Okay,
represent.
so he needs what you're saying is he is not able to come up right now. He needs a continuance.
He's here, Judge. He just is not.
I got you. Is he being medicated?
My understanding was yes, but I'm not really clear on that. I did contact the jail staff to make sure that he had been evaluated.
Okay,
But
is he being medicated with something, like how would they know what to give him? Has his family given them prescriptions, or like how do they know what works for him? Are they going by what happened the last time he was in jail, if there was a last time?
May I speak?
One second, Ms. Walker, hold on just a second. So, Mr. Lynch, is there a particular person that you speak with about individuals who may be medicated in the jail?
if her name is Thibodeau, but what I'll do is I'll send an email to that person to make sure that they're on the list to get evaluated.
Yeah, can you copy me, please?
Oh, yes, Judge, I can.
All right. All right, now, Ms. Walker.
Okay, I'm Deetra Walker. I am Jamal Brown's mother. I currently live in Chicago. So it's very difficult for me to even know what's going on with him when he's there. I did speak with the attorney and I did give him the name of the medication, one of the medications that I know for certain that Jamal is on. Never got a confirmation of anything. I would like to know if there's any way that I can be included in any kind of communications that are happening. Because
how old is Mr. Brown?
He's 26 years old. However, he is definitely diagnosed with mental illness.
I got you. But under the law, Mr. Brown is still an adult unless there's somebody with a guardianship over Mr. Brown. Is there such a person?
No, there isn't.
Has anyone attempted to get a guardianship over Mr. Brown?
When he was in Chicago, we have tried because he is an adult. Once he's medicated, he does his own thing.
I got you. It's very difficult. Are you aware of the organization, the National Alliance for Mental Illness, NAMI.org?
I am not. Dimaje, are you? His sister is on also.
Okay, no problem. So NAMI is an organization that supports not just people with mental illness, but the families who are trying to assist them. I don't have any problem with Mr. Lynch communicating with you if he feels that it is appropriate within the bounds of what he's allowed to do as an attorney. A lot of times family support in this situation makes the difference between somebody getting help immediately and somebody languishing without having that help.
Okay.
Yes, ma'am.
The other thing that might help is my sister is also on the Zoom. She is a Clayton County resident.
Okay.
And so in my absence, she will come like to court and try to communicate with the attorneys and that, because we're so I feel like a lot of times I haven't heard from my child since he's been incarcerated there. I've not heard his voice or seen his face at all.
I understand how difficult that can be, Ms. Walker. And so, Mr. Lynch, if you are willing, the family members can be a resource for you with helping Mr. Brown. So, yes?
No, I was going to say absolutely, and I believe I have contact information, but if
you do have or do not?
I think I do, but just to be on the safe side, if one of y'all could chat to courtroom 304 contact information, I'll make sure that that's in the file.
So
can you repeat that?
So what he's asking is if you know how to use the chat function, chat directly to courtroom 304. And the way you do that is you should look on your screen and there should be a little box that says chat, and there may be a red box with a white number in the box.
And I just am sending messages to make it easier.
Yeah, so he's going to send you a message. You're looking for the red box with the white number in the box. And once you get that message, once you see that, click on it When you open it up, you'll see a name in blue. Click on that name. And once you click on that name, it should have a pull down menu that allows you to choose from the pull down menu. If he's sending it to you, then you should already be on courtroom 304. You shouldn't have to choose it. You'll type your phone number and name, first and last name in the box, and an email address if you have one, and send that to Mr. Lynch. And that'll make it easier for him to ask questions or to communicate with you about Mr. Brown.
Okay, and if it's okay, I'll include all the contacts for his sister and my sister as well.
Yes, ma'am. Also, I don't know if he has a prescription or if a doctor would be willing to send the prescription to the Clayton County Jail for him. But if they were able to do that, then the jail could more closely match the medicines that they are giving him with what he was taking from a doctor. So if you have contact with any of his physicians, if they're willing to fax that information to the jail on his behalf, that would be fine. But with HIPAA, I don't know if they're willing to do it without somebody having a guardianship.
Okay.
All right.
Yeah.
Okay, but please do contact NAMI. It's NAMI.org. They have a lot of resources for families. As I was telling the other gentleman, sometimes families get what we call caretaker fatigue, especially with adults who have mental illness, because like you said, as soon as he's feeling better when he takes his meds, then you no longer have any control over what's going on because he, is back to controlling everything. And so it can be a lot. And NAMI has support groups. They also have information that is helpful, whether in your local chapter or nationwide, okay?
Yes. Thank you so much.
No problem. So what we're going to do is Mr. Brown doesn't seem to be up to taking a plea today, but we're going to see how quickly we can get him back based on, how he's feeling. And then if we can, the state is willing to do time served. And the only impediment to that is I can't take a plea from somebody who is not competent to understand the implications of their plea. Okay. So as soon as he's able, then that's what we're looking at as far as he would get out immediately. And you having your sister there could help him to transition from jail to the outside.
Okay.
All right. All right, Ms. Walker. I'm gonna pray for y'all and wish y'all well. I know how hard it is to be a mom and you can't touch your baby and help control what's going on with them. Okay.
Yes.
All right. All right.
Thank you all so much.
No problem. I hope I've answered all your questions.
Yes.
Yes. Yes. Somebody else was calling me. Oh, okay.
No, I just said thank you.
Oh, you're welcome, ma'am. All righty. So we'll try and keep in touch and try and help Mr. Brown as much as we can.
Thank you.
All right.
Thank
Take
you.
care.
I think we can leave.
Yes, ma'am. Tiffany Monique Chambers.
So what's the reset for Brown, Judge? How many days?
Yeah, just give it 30 days. If they're able to bring him back quicker, if we could get him on, if they can bring him back quicker, that would work. Because I want to make sure, like if the meds kick in and he's able to understand what's going on, I would like to take advantage of that timing.
So say 30 days?
Yeah, so 30 days from now.
Okay.
All right. And information for Ms. Chambers.
Your Honor, that will be a negotiated plea.
All right, I'm ready, Ms. Chambers. Well, did y'all want to just go through the calendar before we start bringing people out? Let's do that. Because I think that'll help with the deputy having to be able to organize. Collier, Preston Kamay Collier.
Judge, I'm gonna ask for another reset. He is still pending an evaluation. We did just follow up with the jail about medication, but he is still in the same status of pending the eval. Should be should be completed pretty soon based on the timeline that I'm seeing. But the order has been signed and we are still, and I'll continue to follow up with Mr. Collier because I thought he was pretty close to maybe not needing to go through the whole process. But my understanding, he's currently not totally compliant with medication. And on our last meeting, he was not ready to resolve the case in any way that the
I
court
got you.
would say.
So we'll put Mr. Collier on the same 30 days as Brown, Ms. Val.
Yes, ma'am.
Thank you. All right. Holloway, Justin Adam Holloway. That's the petition.
Yes, Your Honor. Defense is requesting a hearing on that to be heard on the violation alleged.
Okay, Ms. Chang. So how long do you need for it to set up the hearing?
We could do it next week. Next.
I'm asking Ms. Chang.
We would have to subpoena us or the state. I don't know if the state would help in subpoenaing the witness, the victim on the case, Your Honor.
All right.
So a couple of weeks. I'm not sure how long the state would
Ms.
need.
Val, can we get 2 weeks on that? Or actually 3 weeks?
Thank you, Your Honor.
Let's do August 19th.
Okay, thank you. August 19th, 10 a.m.
Yes, ma'am. Thank you.
Thank you. All right. So Holloway will be a hearing. Deputy Holloway can go back with the sheriffs. Anthony Quinn Jenkins.
Judge, I did speak to Mr. Jenkins. He does want us to be appointed. We do have a negotiated plea ready for that matter.
So, all right. Next is Joseph Keith Johnson.
Your Honor, I'm waiting to hear back from the state on negotiations.
All right. So we'll put that down as a conference so we can an announcement. Next petition is Khalil Jones.
Judge, we're gonna stipulate that there was a violation as alleged, and we're gonna ask the court to accept Ms. Chang's recommendation. That's the announcement.
Okay. And then Patrick Wesley Jones.
Your Honor, that will be a plea.
Okay.
Negotiated plea.
Joseph Healy Kinsley.
Judge, Mr. Kinsley is going to enter a negotiated plea.
Okay. Melvin Rigby Jr.
Your Honor, that would be a negotiated plea.
Emmanuel Santana Cambrera.
Your Honor, it's my understanding that Mr. Sperling is the attorney of record on there. We do have Ms. Bermudez here to interpret, but I've not seen Mr. Sperling.
All right. Do we have any information from Mr. Sperling, a contact, conflict, or leave?
Not that I've seen, Your Honor.
I haven't heard from him, Judge.
Okay. All right. We'll just hold for a second on that. Earl Shavers.
Judge, I expect a resolution today, but I am still working through that with Mr. Shavers.
All right. Smith, Edward Maurice Smith.
Your Honor, that will be a negotiated plea.
Kamani Jerome Walker.
Judge, Mr. Walker is in custody. His family members are here in support. I am still speaking with him. I expect we're likely entering a not guilty plea today, but I do want a conference with the state just a bit further to see if we can potentially work something out.
Okay. Akea Ward.
Your Honor, we're stipulating to the violation. However, we would like to leave the recommendation up to you on this matter.
Okay. And Quan Wright?
Judge, that's gonna be negotiated, please.
All right, so it looks like we got a good bit. Let's go over the calendar. Barnes is going to be a reset, Brown reset, Chambers plea, Collier reset, Holloway reset, Jenkins plea, Johnson conference, Jones stip and agree, Jones P is going to be a plea, Kinsley plea, Rigby plea, Santana Cabrera. The attorney's not here, so we may have to reset this for a week. And I want to communicate that to Mr. Santana Cabrera so he's not in some kind of limbo. So if possible, can we put Ms. Bermudez in the attorney room with Mr. Santana Cabrera so she can tell him that we'll be continuing this for a week so that we can get information about his attorney.
I'm on the phone with their office now, Judge.
Okay, well, before we do that, let's see if Ms. Val has anything. Shavers is a conference, Smith is a plea, Walker is a conference, Ward, stip and agree, and Wright is a plea. Okay, all right. So I'll be right back and we can start lining the pleas up. I don't care what order we take them in, whatever's easiest for Deputy Castro.
Your Honor, I'm sorry. I just wanted to speak on Holloway again. Is there any way we can do it in 2 weeks?
No, she's got to subpoena them.
2 weeks is not ample time to subpoena officers.
My understanding is there's not just officers, there's a victim too. So I'm not sure how long it's going to take to subpoena them. Those are resources that are through the state or through probation, not me.
Yes, Ms. Chang, is there any way we could do it in 2 weeks? Because he's trying to be heard on the no violent contact. And as you know, there is an order for him to see his son. And unfortunately, the alleged victim here is the mother, and the son lives with the mother.
Your Honor, I don't think the state will be able to get it done in 2 weeks. So the simple fact that for the simple fact of how our calendars are stacked, we've got, in less than 2 weeks, we've got a big motions calendar. We've got our.
But 3 weeks, I think, is ample for them to be able to get it done. So,
In that matter, Your Honor, is there any way I could conference them with Mr. Holloway and then get back, because I'm not sure.
Yeah, that's fine. You can conference with Mr. Holloway.
Thank you.
Okay, no problem. I'll be right back.
Yes. Mr. Lynch. Johnson, how much? I'll reduce to 65. Yeah. Are you going to? Right, yes, yes. Do you think I can? Yeah, I gotta talk to one of those two. You know what? I think she texted me her number. I'll just call her. But sometimes you call and can't answer your phone. Yeah. Let me just see. Sorry, I didn't see it. I was assuming it's just something.
Hill, assuming it's $200 fine. She wants rental cars. Expenses.
All right, we ready on please?
Yes, I think an attorney from Sperling's office is.
All right. Attorney Brown?
Hi, good morning, Judge Hayward. I apologize. We had this case scheduled for a preliminary hearing coming up, but I presume the state has drawn an accusation and we were scheduled for arraignment.
Yes. Go ahead.
Is anyone from the solicitor's office available to talk to me about working out a negotiated plea or?
Yes. Mr. Tipton is in the courtroom. Mr. Tipton, do you want a few minutes to speak with him before we start the pleas?
I would, Your Honor. I'm also going to need a few minutes to talk to, I'm not sure if she's still on, but there was a young lady, a Miss Muhammad, who was on earlier, who was a victim on a case that I need to speak with. I'm not sure if she's gotten off of the.
I'm still here, Mr. Tipton.
Okay. Yeah, I see him, Miss Robinson.
Yes, ma'am. Muhammad was my former name.
So I need to speak with her after I speak to Mr. Brown.
All right, so let me know when you're back in your office and I'll set him up.
Your Honor, I have my device.
You got your device? Okay, no problem.
Step into the conference room.
All right, so Mr. Robbins, Mr. Brown and Mr. Tipton, I'll put you in breakout room number 2.
And Judge, could I, for the record, if we're not able to reach an agreement today, just formally put on the record that we be waiving arraignment and entering a plea of not guilty, asking for 10 days to file motions?
Sure. Once you've talked to Mr. Tipton, if you all aren't able to reach an agreement today, that's fine.
Okay, thank you.
Mr. Brown, remind me, how old is your client?
Give me just a second. I'll give you that answer.
Okay, because I want to make sure that I think I know one of the folks on our calendar today may need to have sight and sound separation under Plea.
He is 17.
Your Honor, I think that he's going to need sight and sound separation, so we just need to make sure that he gets that in the jail, because I think PREA says is worded so that everyone under 18 has to have sight and sound separation. So Mr. Brown might want to reach out to the jail and make sure that that's happening.
All right, Deputy Castro, let me know who I have to talk to about that.
Yeah, he's under 18, so they have. So PREA basically says that they have to separate sight and sound, so they have like immediate access to adults. I'll double check PREA before we go down, but basically it's Prisoner Information Act. And younger offenders are considered to be acts.
All right, so Mr. Tipton, I'll follow up on that, and I'll set up the breakout room for you and Mr. Brown in breakout room number 2.
Yes, Your Honor, just have to gather up all my files.
No problem. Mr. Lynch, did you have an announcement?
Judge, I mean, I do. We're ready on pleas. I mean, as far as Mr. Shavers, I know that I had announced conference that's going to be a negotiated plea.
Okay.
For the OTB stuff, like Miss Hill, I believe we're going to get that resolved. I just the state is figuring out whether there's restitution wanted, and if so, how that's going to be handled. And then for Mr. Taylor, we're still waiting. So,
okay.
But, as far as the in custody cases.
All right. So as soon as Mr. Tipton gets off the phone with Mr. Brown, and then he's going to speak with one of the victims on one of the cases, and then he'll be available and we'll just run through the pleas. So any other conferencing you need to do, go ahead and continue to do that now. And then once Mr. For Ms. Bermudez, Mr. Brown is here for Mr. Santana Cabrera. So as soon as he finishes speaking with Mr. Tipton, he may need to speak with Mr. Santana Cabrera. So we'll just try and get that done as quickly as we can.
Yes, ma'am. Thank you.
Thank you. All right, ladies and gentlemen, so just keep your devices muted until we're back. Thank you.
Which one? You gonna get up. You gonna get up. Yeah.
Ms. Terrell,
Yes.
can my device be placed in a breakout room with Mr. Shamar Thorp?
Yeah, one moment, Judge Hayward would have to do it for you. I don't have access.
Okay. Done.
Me, Your Honor.
Ms. Tortorello, I already set that up. Mr. Tipton, yes, sir?
Yes, Your Honor. Attorney Brown and I were requesting a bench conference.
Okay. I will join you.
Thank you. We'll go back to the breakout room. Thank you, Your Honor.
Mr. Brown, if you, I guess, activate your screen, it should come back up, the invitation to the breakout room.
Got it.
All right, so, Mr. Brown, with respect to Mr. Santana Cabrera, do we need to bring him up and have Ms. Bermudez, explain to him what's going on?
We don't, Judge.
Okay, so it is my understanding that you wish to enter a plea of not guilty for Mr. Santana Cabrera, and that you also have some outstanding discovery before you're ready to go on a trial calendar.
Correct, Judge.
All right, so, once the discovery is complete, just let me know, and we'll put you on the next available trial calendar. As an active inmate, he'll go to the top of the trial calendar, as you know. And then if y'all decide to pay the bond, he'll go in order of the cases that are already pending.
Understood.
All right, thank you. Tell Mr.
So
Sterling
much.
I said hello.
I will.
All right, take care. All right, so Ms. Bermudez, Mr. Santana Cabrera, I guess Mr. Brown is going to communicate with him soon, I think. And so we don't need you to remain. And I think that was the only Spanish speaker that we had on the list for today. You're muted. Courthouse is muted.
Yes, ma'am.
All right, thank you so much, Ms. Bermudez.
And Your Honor, if I may be placed in a breakout room with Ms. Robinson and Ms. Hemphill, please.
Okay, once Mr. Tipton comes out of the breakout room with Ms. Hemphill and Ms. Robinson, we should be able to roll with the pleas. Attorney Tortorello is still with a client, so she should be out around the same time as Mr. Tipton, I would assume. Mr. Tipton, you're already in breakout number 2. Breakout room number 2, I'm gonna put Ms. Hemphill and Ms. Robinson in breakout room number 2. And then when you all come out, and you can make your announcements. All right.
Your Honor, we have several announcements before the court. However, we are just waiting on ASG Tipton.
That's fine, thank you. Mr. Tipton, you ready?
Your Honor, I'm relocating back into the courtroom now.
Judge, I think we need to stand by for a minute. My apologies.
Okay.
Your Honor, I'm back. I apologize. I got pulled out by someone.
All right. We should be ready to roll now.
Yes, Judge, I believe we are.
Okay.
You want to do probation, the one probation case first?
Yeah, that's fine.
Here. That's Khalil Jones. What do you need?
Okay. I thought there was actually two, Ward and Jones.
One was reset for a hearing, I believe.
The one that was reset for a hearing is Holloway.
Yeah, I have an announcement on him, Your Honor, and.
Okay, go ahead.
Okay, on Mr. Holloway, he would like to stipulate to the violation and leave the recommendation up to you, Your Honor. For Mr. Thorp on the out on bond calendar, on the arraignment calendar, he is interested in PTI. He provided me with all his contact information and he's willing to pay what is required for the PTI program. Now leaving it to the state to see whether or not they're willing to move forward with him at this point.
Okay, do we know why? Was it a wrong address? He never got notice? What happened?
From my understanding, Your Honor, he was never informed that he was accepted into the PTI program.
Okay, so we have all the current information.
I do. I have his address, Your Honor, his phone number, and his email to share with the state.
Okay, Mr. Tipton.
I apologize, Your Honor. Mr. Lynch was speaking with me.
Mr. Thorpe, regarding PTI, whether you guys are willing to take him on. I got all his contact information and everything.
Okay, and he is an OT.
Yes.
With regard to Mr. Thorpe on the OTB calendar, I would be willing to resubmit him to pretrial diversion if Mr. Thorpe is accepted by Ms. Menard Knox.
All right, so let's reset Mr. Thorpe for 30 days, Ms. Val. Do we have anything on Douglas?
He's appointed.
Did you talk to him? Yeah, that's. Judge, that's gonna be a plea.
Okay, who's out front? Who's here?
This is Khalil Jones for, he's got a petition.
Okay.
We're gonna stipulate.
1 second. All right. All right, so Mr. Khalil Damari Jones, raise your right hand for me. Ms. Chang, raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Ma'am.
All right, Ms. Chang. All right,
I do, Your Honor.
Sir, you're before the court on 2025 CR 00494. You're before the court for a petition for revocation of probation. You entered a plea to criminal trespass on the 4th day of February 2025, sentenced to 12 months on probation. You have 6 months and 18 days remaining. It says you failed to avoid injurious and vicious habits, that you've tested positive for the metabolites of alcohol on June 5th of 2025, and you failed to attend a community support meeting. You were ordered to do one community support meeting at least once per week, dedicated as cessation of alcohol or illicit drugs. The last date documented was June 4th of 2025, and you failed to pay your $65 in arrears. Okay, Mr. Lynch, what's going on with Mr. Jones?
So just a couple things, and I'm gonna let Mr. Jones speak as well. I think that other than the positive test, he has been a pretty successful candidate on probation. I think that may be reflected in the recommendation from Ms. Chang. I know that when he came before you, Your Honor indicated to him that he needed to get himself a job and get out of his mother's home, and I believe Mr. Jones has done that. As far as the community support meetings, I believe that he was attending. So I'm not sure if he hasn't documented.
Yes, I sent it to my email.
I'm gonna let you talk. I'm gonna let Mr. Jones speak to what extent he's done the community support meetings, but I believe he has been active in that. And I believe that up until this test, Mr. Jones was testing negative for alcohol and substances. And so the actions that resulted in a positive test were a mistake, but I think that he has been a pretty successful candidate on probation. And so we're just going to ask that you accept Ms. Chang's recommendation.
Ms. Chang?
Your Honor, probation recommends that 5 days be revoked, credit for time served as of July 10th. Continue on probation and drug screen each report.
All right, Mr. Jones?
Yes, ma'am.
Tell me what's going on, Mr. Jones.
Everything been going pretty smooth. The day of June 5th, when I reported, I had took some mouthwash and brushed my teeth with it and gargled it.
Mr. Jones, no, sir.
That's the only thing I could think of that indicates that alcohol.
Mr. Jones, now look, when you're in Mr. Jones, when you're on probation, you and I are in a relationship, and you don't lie to somebody you're in a relationship with. We go together till your probation is over. So don't lie to me. First of all, for you to have the metabolites of mouthwash of alcohol, you have to ingest it. It has to go through your system. It has to get into your bloodstream and your urine stream. And so don't nobody drink mouthwash unless they're trying to ingest alcohol. So if you washed your mouth out, but it showed up in your urine, that's a problem. So what we're not gonna do is lie to each other. We clear? All right. So you want me to follow the recommendation of the last thing you want to do is just straight lie to me like I'm just really not smart. I'm not the smartest person in the world, but mouthwash ain't making you test positive for alcohol, sir, in your urine. That's just not going to happen. I finished high school science. I went that far. Okay. Mr. Lynch, he told you this and you said, hey, talk to the judge before. I mean, don't tell me about your privileged conversation, but I'm just saying. So, Mr. Jones, you got a job?
Yes, ma'am. August will make a year of doing dispatch.
Okay. I'm gonna go ahead and allow you to go back to probation. Yes.
May the state be heard?
Yeah.
Your Honor, state would request that he have to do an additional community support group meeting every week for the next 2 months as part of the treatment with once he returns to probation.
Judge, I would just ask that the same community support meeting be there if he's documenting that. He hasn't had any other positive drug or alcohol screens.
Well, today is July 15th, and he hasn't documented one since June 4th. So that's not really helping him. And that big whopper he just told me pretty much tells me that he probably needs a little bit more community support because unless he's straight drinking scope, yeah. All right, so defendant shall return to probation with 5 days revoked credit for time served. Defendant shall continue and complete all special conditions as ordered and shall have one additional community support meeting per week and test at each report for alcohol and illicit substances.
Thank you, Judge. Thank you.
Remember what I said, Mr. Jones. Don't lie to me, don't lie to yourself. We good?
Yeah.
Your Honor, if I may give him his next appointment.
Yes, please, because everything I just typed in disappeared. So let me do that again. It happens often. While you give him his appointment, that's fine.
Thank you, Your Honor. Mr. Owens, Mr.
Yes,
Lynch, I'm sorry. And Mr. Jones, if you'll report Thursday of this week, July 17th at 10 a.m.
Thank you.
Thank you.
Thank you. I can go out, Sheriff. There's another VOP you want to get done? Who? Holloway. Judge, we can do Mr. Holloway next and hopefully get Mr. Kang out of here.
Yeah, that's fine.
We also have Ward. There's one more after this one.
Your Honor, we are ready to be heard on this matter.
1 second. All right, Mr. Justin Adam Holloway, you're before the court, case 2021 CR 05109. You were before this court for a simple battery, family violence, simple battery, and family violence again. On the 30th day of July 2024, you were sentenced to 12 months on probation. You have 4 months and 11 days remaining. The sentence was told because you failed to report. You failed to avoid contact with the alleged victim in this case, or with the victim in this case, Guana Holloway, or any member of the victim's family while on probation as ordered by the court on July 30, 2024. You failed to report on July 15, 2025. I'm sorry, February 15, 2025, February 28, 2025, and in person within 10 days of March 3rd, 2025. You were last reported by mail January 3rd of 2025. You failed to pay. You're currently $50 in arrears. All right. What's going on with Mr. Holloway, Ms. Tortorella?
Your Honor, stated on the record before, we are stipulated to the violation, however, not this difference from an admission to the violation. I want to invoke OCGA 24-2-01, which is judicial notice. I'd like the court to take judicial on an order to modify probation conditions, which was filed on August 5th of 2024. And it was signed by Your Honor in this court's jurisdiction, state court. The court filing for this order, Your Honor, allows contact with my client's, it allows my client to have contact with his 9-year-old son only, okay? No allegations from probation regarding my client involves any sort of violent contact against the alleged victim. My client has been going to the victim's house when she has not been present to see his son only. The order, Your Honor, actually sets my client up for failure as it only allows him to have contact with his son. And as Your Honor is aware that when there's a child involved, there needs to be some level of co-parenting. We are willing to move forward if Your Honor allows him to go back on probation with no contact with his son until he's able to get legitimized and have visitations with his son. And we feel that 120.
So if I don't allow that, what we doing?
I'm sorry, not allow what, Your Honor?
You said you're willing to move forward if I do certain things. I may not do those things. So what will we do if I don't do those things?
We will be accepting your recommendation, Your Honor. We do feel that 120 days is excessive and extremely punitive for this matter.
Okay. Ms. Chang?
Your Honor, probation recommends that 120 days be revoked and the case be closed.
Okay, so I guess the hearing is where I would have figured out why he's even here. What happened? Mr. Tipton, do you have any information about what caused Mr. Holloway to be back before me?
If I may, Your Honor, I'm looking to see if I have it right now. Your Honor, I don't have any information regarding that.
Because the problem is both of these parties should have gone to a superior court and figured out some type of parenting plan or parenting structure. Yeah, I modified it for him to be able to see his son, but under certain conditions. And if he's having contact with other members of the family, it is because nobody took the opportunity to go before the court, to the superior court, and get the necessary paperwork that they need to give them guidance. So at this point, I got Mr. Holloway's attorney telling me, oh, he only had contact with his 9-year-old son as per the order, but he's before me in orange jumpsuits with alleged violation. Let's talk also about Mr. Holloway. I put you on probation and then you disappeared.
Yeah, can I speak? Yeah. Is that what? Thank you, Ms. Hayward. I'm glad you gave me the opportunity to speak on my own behalf. First and foremost, that's exactly why I wanted to speak was, as Ms. Chang is fully aware, I'm sure she came into the probation. I was very unstable in residence. I had to go to several recovery places during this probation and wind up changing many addresses. And it has been you know, a unique situation where I've had to contact her and she's had to contact me. We've had to set up different addresses and stay in tune with one another or whatever. But that was in the earlier parts of the probation. I did find stability. Eventually, I wound up having to withdraw from school due to that instability and just a lot of circumstances in my life. If you remember, if I know you have many cases, but if you remember the case, the one, Jordan Fuller was present in the courtroom, and she did speak up on my behalf. And you had asked her, you know, you're like, this is a 4-year-old case. And you was like, has there been any negative occurrences since then? This is a 2024 conviction. And she said, not at all. She said, we haven't, you know, had any negativity or anything. And she was like, well, we do not want him to not have contact with his son because he does have a wonderful relationship with his son. And that's when
I remember. And then you were getting back into school.
And I was getting back into school. Well, there has been some instability in my during that period. I did go back into the free world, but there was no criminal intent ever whatsoever.
Who facilitates the contact between you and your son?
So the contact between my son has only been strictly me and my son. I've never had contact with her personally, period. Like her or the daughter, every time I call and speak to someone, it's my son. And I say, you know, I might call him and say, hey, I want to see you or whatever. And the only question I would ask him pertaining to them is, your mom or is your sister home? And he would say, no, they're not. I say, okay, well, I'm going to stop by and see you. And she does have a ring.
She has a ring.
And the last time that I did go, you know, that she did communicate with me, and I, you know, through that, and I left immediately, you know. But never one time have I entered the address. Never one time have I argued with neither one of the victims. Never one time have I had personal contact with them, criminal intent to contact them. Never once have I had been frustrated, argued. I've turned myself in to take care of the situation because I didn't need anything under me that was holding me back from being productive. I'm a university student. Right now at the moment, I'm withdrawal, man. So I'm not currently in school, but I am. But
I remember the situation because the mother and the older daughter, like not old, but she's an adult herself.
Yes, ma'am.
Who's the sister of your son, both testified that there wasn't an issue currently with you having contact with your son. You were a good father. Yes, so that's why I did the modification. This is the issue that I have though. Y'all are really gonna need to work out, because this is not a long-term plan. This probation will eventually end. This is not a long-term plan. Y'all are gonna need to go to Superior Court and work out the situation so that there's visitation custody, all of those things that the Superior Court can give guidance to. And as long as you're going by what the Superior Court designates, then you shouldn't have an issue.
Yes. The only issue, if you allow me to speak real quickly on that, the only issue with that is like I said, you know, I was having a lot of instability problems, and
I got you.
You know, and that taking that into consideration, that me getting control of my instability, getting control of stability and residence was priority. And I had a lot of other responsibilities going on. I had to, like I said, I had to withdraw from school. Getting into a courtroom, there was not even a way that I could communicate with her and say, hey, we need to be more cordial without, you know.
Well, you're not supposed, that's what I'm saying, is you don't have to to talk to her. What I'm trying to talk about is y'all have a 9-year-old. There's at least another 9-10 years of you having to have contact with each other to co-parent. The issue is not that I'm really concerned about you all having a relationship or talking to each other. What I want is an orderly co-parenting situation. And the only way to do that in the long term is for the Superior Court that has jurisdiction over family matters to make to kind of lay it out for you. Now, I understand a lot of people have concerns about money. There are ways where if you told them that you were indigent or did not have the filing fees at this time, you could apply to have a waiver of those things. So those are things that could happen if you went to Superior Court. But what I'm asking is, I need you to not, like, this shouldn't be an issue ongoing.
Yes, ma'am.
The sister and mother of your child advocated for you to have a relationship with him. So this should not be an ongoing thing with respect to that. I get the instability part of it. Are you working currently?
Yes, ma'am. I have. I'm currently staying in LaGrange with my cousin. He has a lawn service business, and I am working with him. I came to turn myself in to take care of the situation, given that he had given me time to do that. What happened is, judges, I didn't realize I didn't realize how serious the situation was until, you know, until it seemed as if I may be in some trouble here. You know, like, like my probation was actually in like revocation status. There's been no criminal intent, no criminal behavior on my part. And I accept whatever you. I
got you, but Mr. Holloway, you know you got to report, so you can't just not report. And I get the instability part. That I see that a lot. That's happening a lot. So I'll give you a little bit of leeway on that. And I don't, Mr. Tipton, is there any kind of police report or violence or threat of violence with Ms. Holloway?
Your Honor, as I've stated, the state does not have a police report at this time. So I'm trying to see if
Ms. Chang, how did this come to your attention?
Your Honor, we have a statement that I sent to the court. It's with the petition, and there's a police report and a statement. The police report is dated February 11th. It's Clayton County PD.
Okay, hold on. I got it. Wait, let me see.
And there's also a statement by Guana Holloway on February 28th, 25. That's attached.
Your Honor, if I may.
Hold on. Okay, the police report essentially says what he does. There's some behavior that is violative of what I ordered. However, it is not violent or harassing. So hold on. Here's the police report. On February 11th, 2025, around 16:57 hours, so that's 4:57 p.m., I responded to the reference to a disturbance. Upon arrival, I made contact with Guana Holloway. Guana stated that her former husband, Justin Holloway, of 3 years, continues to contact her via message and email. Guana says Justin shows up at her home as well without her permission. Guana stated that she had a no contact order against Justin, but was unable to provide the documents. Guana stated that Justin came to the incident location on February 11, 2025, around 1500 hours, that's 3 p.m., and gave their juvenile son money. I asked Guana if she had any video footage of Justin coming to the incident location. She stated that she did not have any proof that Justin came to the incident location on February 11, 2025, and that she didn't want her juvenile involved in the police report. Guana provided screenshots of messages and emails from Justin. I observed the messages and emails from Justin to be messages asking Guana to not allow their juvenile son around Justin's mother and informing Guana that Justin is going out of town. Guana provided me with Justin Holloway's name and date of birth, and after running his name and date of birth on MCT, Guana was able to confirm the individual who populated GCIC as Justin Holloway by the photo attached. I attempted to contact the warrant division to confirm the status of the no contact order has in place, but had negative contact. And then they uploaded the text and emails. So, all right. So here's the thing. I ordered Mr. Holloway that I ordered that he can have contact with his son. The contact was going to be mainly through the sister. She may have moved out or gone on her own. The contact essentially seems to be protective of the son. Don't have him around my family, not her family, my family. And he did, if what is alleged is believed, he did go see the son with no contact to the mother and give her money. So with that being said, I would tend to agree with Attorney Tortorello that 120 days would be excessive. the only way to contact, like literally the only way to contact the child is through his mother, but the contact should have been focused on the child, and it seems that that's what the case was. So in this case, my biggest concern is Mr. Holloway wasn't in contact with the court for a period of time, which he has explained with respect to him being in several rehab situations and having instability with respect to his housing. Mr. Holloway has stated that he now is in LaGrange, is having the opportunity for employment with his cousin. So walking through this situation, I don't believe that the contact is a major issue for me. But like I said, for me, it would work better if y'all went through Superior Court. That is my desire for this situation, because then we wouldn't have this happen. Yes, ma'am.
It has something he wants to say something.
Your Honor, I'm not sure. I just noticed the report that was sent to me by Ms. Chang. There was also a statement written by the victim that gives the state a lot of concern.
Okay, let me go back to that. Hold on, because all I have was here we go, victim statement. My ex-husband, Justin Holloway, has come to my home several times, banging on the door. He has come at different times. This was mainly in January of 2025. Once he came close to midnight, this was towards the end of January. Each time he has used the excuse of trying to get in touch with our son. Our son has his own phone where Justin can talk with him and has been in communication with him. Justin Holloway has also been reaching out to my family members and significant other. Each time he's making the excuse that he was checking on our son. When I asked our son if he's spoken with his dad, his response is yes, that Justin has called him. Even though Justin is not being violent, he is trying to show a form of intimidation as if he was the authority to come to my home anytime he wants, and uses the excuse of checking on our son.
Your Honor, I understand this is for a subsequent matter. However, the state has no proof whether in fact this happened. The police report even states, Your Honor, that the only proof the alleged victim could provide was an email regarding his son. It seems like this is more so a custody matter revolving their child, and that this is more centered towards the son. I would ask again, Your Honor, if you would consider him having no contact whatsoever with his child at this time, or stay away from the alleged residence until he gets legitimized and court order.
Okay, here's the thing. Mr. Holloway and Miss Holloway and Miss Holloway are gonna have to work out the custody thing. That's not my bailiwick. I did say he could have contact with his son, but Mr. Holloway, you're not to be banging on her door at all times of night. The contact should have been with the son or with the biggest sister, who said that she would help facilitate, but it was essentially the son. The son has a phone. You're to use that phone exclusively. The court, because of the different violations here, the court is going to state that Mr. Holloway should do at least 30 days. He should have 30 days revoked. And then does he have any other special conditions?
Your Honor, he is, according to one of the orders, he is part of the Potter's House rehab. So he could continue there. I believe his graduation date is September 21st of 2025. So we could go back to that.
Ms. Chang?
Your Honor, that modification was approved by Your Honor on September 18th of last year.
Yes.
The defendant entered the Potter's House on September 9th, 2024, but he left on his own, according to the Potter's House, on October 12th, 2024.
Okay. All right. So Ms. Chang's recommendation is 120 days. I don't think it rises to the level of 120 days. I do think that there is a violation, more of a technical violation. I don't believe Mr. Holloway has been violent, but I do believe he's involving himself maybe a little bit too much in Miss Holloway and her current situation. So Mr. Holloway needs to contact the Superior Court. The court is going to revoke, let's say, 45 days. Yes.
Your Honor, you said 30 days?
Well, I initially said 30 days. The court is going to revoke 45 days. Mr. Holloway will get credit for times already served since the date of lockup. Upon completion of the 45 days, then the probation will suspend.
Thank you, Your Honor.
Thank you, Ms. Hayward.
All right, Mr. Holloway, the only way to make this work is to get yourself together, go back to Potter's house and hope they will take you.
Yes, ma'am.
All right, because if you don't get yourself together, your son is not gonna have anybody to support and look up to. He needs a father. Boys need their fathers, and you gotta be a father.
One thing I do take pride in, ma'am, Ms. Hayward, is being a great father. But I do recognize the situation, and just like I told my my attorney, I said if it does take me refraining from having that relationship with him just for a moment to get into court and get visitation at least, I would never go for sole custody.
I don't want you to not have a relationship with your son. What I want is for your son to rely on the relationship he has with you. He can't have a good relationship with you if you're in and out of rehab and not completing it, or if you're unstable as far as housing, or if you're in an orange jumpsuit. Those are things that don't make for a good father-son relationship. What you need to do is to get yourself together and make a petition to Superior Court so that y'all can work out all of the co-parenting issues that y'all have. Because this is just the beginning. He's 9. He's got a ton of time left to need you. And at this point, you really need to be there, because this is the time when they get into extracurricular activities. They're doing baseball, they're doing football, they're doing, and the dad needs to be there. Like, you need to be there. And so get yourself together.
Yes, ma'am.
All right. So 45 days credit since the date of lockup. Once you serve the 45 days with credit, and then this will suspend. But you really need to get it together. Like, one step at a time, make a plan.
Yes, ma'am.
Okay. You can be, I believe in your heart you are a good father, but you cannot be a good father without being stable.
Yes, ma'am.
All right. You can go back to the sheriff's office.
And Your Honor, there's one more probation case. It's Miss Akea Ward. Your Honor, Ms. Ward is present before you.
Got you. All right. All right, Ms. Chang, I'll send over the Holloway order.
Thank you, Your Honor.
All right, Ms. Akea Ward, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down, Ms. Ward. Ms. Ward, you're before the court on State of Georgia versus Akea Ward, 2022 CR 07476. Defendant entered a plea on to theft by shoplifting on the 11th day of June 2025. Was sentenced to 12 months on probation. You have 10 months and 25 days remaining. It says that you violated the law by getting the new criminal offense of driving on a suspended or revoked license and knowingly operating a vehicle without insurance on or about July 3rd, 2025. You failed to report to probation on June 18th, June 27th, February 2nd. You last reported on July 2nd. You last reported on July 8th, 2025. And you failed to complete community service. You have 40 hours ordered, but none documented. Right, Ms. Tortorella, what's going on?
Yes, Your Honor, we're stipulating to the violation and leaving it up, the recommendation up to Your Honor. My client, it's my understanding that she never received a deadline from probation for community service. No letter.
No. Nope. No. That does not fly because I know the speech I give everybody. So go on to the next thing.
So I just want to convey before the court that it's my understanding that she did not receive communications. And therefore we obviously we're stipulating to the violation. We are asking for credit for the time served as far as the probation revocation and for her to be placed back on probation afterwards.
Okay, now what communications is she seeking? Like if we put her back on probation, what communications are going to be sufficient for Ms. Ward to know she's not supposed to do what she did?
Your Honor, it's my understanding that email would suffice. Is that correct? Email.
And we're supposed to tell her what? Do what I asked you to do when I met with you the first time?
It's my understanding, Your Honor, that she did receive information regarding how.
That's why that doesn't work, because I give her a whole speech. Then she meets with our probation expert, Ms. James, who gives her the whole setup of how this is going to go. Then you meet with your probation officer. So you're saying you never met with the intake person who to answer your questions and give you intake? Okay, then how do we have your information and Ms. Chain got you assigned? How'd you get assigned to Ms. Chain?
I was supposed to, after the virtual court date, I was supposed to receive an email from someone. I only heard do 40 hours.
Okay, so no, that's not how that works. If you were virtual when we did your plea, I put you in a breakout room virtually with the probation expert before you leave court. So if you didn't appear for the virtual intake, but I don't know how you would have been assigned to Ms. Chang if you didn't have that.
Yes, ma'am. Well, I guess the breakout, if that's, I don't remember her name, but Ms. Chang. All I remember was 40 hours community service, and I will receive an email. And I have been looking for an email since that day. Sorry that I'm not used to this.
Your Honor.
Yes, Ms. Chang.
If I may, I have here that Ms. James sent the email with documents, intake documents, on June the 13th, which is Friday at 9:50 a.m. to akea.ward@gmail.com.
No, it's Akea at ymail, stands for yahoo.com. So it's akea.ward at akea.ward@ymail.com.
Okay. It wasn't returned to my knowledge. So, but that's where it was sent.
They got something called Y mail?
Yes, Your Honor.
It's a Yahoo. It stands for Yahoo. Y stands for Yahoo.
Okay, so, but you did come in on July 8th? How did you do that?
Because I had to buy a new phone. I have my phone, my first phone screen was cracked. Finally just listened to my voicemails. And as soon as I heard it, as soon as I heard a voicemail saying I had been missing the report to report, they told me to come in that day at 1:30, and it's a lot of stuff going wrong I guess for the right reasons, but I had to make it up here, and that's when I was arrested. But I was not aware of like me reporting or anything. So
Ms. Ward,
yes,
what you are recounting is the perfect storm of foolishness, and that has never happened. Like, I've never had anybody tell me they didn't get their email. Never had anybody tell me that they didn't understand that they were supposed to report for probation and do what they're supposed to do. Not to mention, you got 2 additional charges. So not sure why, I guess that I didn't say that too. Hold on just a second. We're responsible for not telling you not to get additional criminal charges while you're on probation. Ms. Ward, how old are you, ma'am?
I'm 38 years old.
Okay, it's well past the time of people holding your hand. So what we're gonna do is we're gonna restart. Miss Chang is an excellent probation officer. Miss James is an excellent intake professional. And so if you claim you didn't get that email, okay, we're gonna reset from this point. Miss Chang, what was to be your recommendation in this case?
Your Honor, probation was recommending, because of the new charges, that 30 days be revoked, suspend the balance of this case and close it. However, I don't object to her reporting back to probation after the service
Now,
of
Ms.
7 days
Ward,
that she served.
is there anything you're confused about now that I have Ms. Chang and myself here? Ms. Chang, can you read her sentence out to me for me?
The sentence reads, it's a 12-month probated case. The defendant is to perform 40 hours of community service as determined by the probation office. The defendant shall not go upon the premises named in the accusation or located at Walmart at 2940 Anvil Block Road, Ellenwood, Georgia, provided probation to be suspended so long as the defendant does not return to Walmart.
Right, Chang, you broke up. I didn't get that last part.
Provided that probation to be suspended so long as the defendant does not return to Walmart and completes 40 hours of community service.
So, Ms. Ward, all you had to do was the 40 hours of community service and report to probation. That's all you had to do.
Right.
You haven't done any of it. Yes, Mr. Tipton?
If the state may be heard, the state would like to make sure the defendant's on notice that if she violates her probation again, the state will request a total revocation of the balance.
I would object. Your Honor, I'm confident that my client will not violate her probation again. However, I object to that, Your Honor.
Well, they can request whatever they want, Ms. Tortorello, just like you can request whatever you want. I mean, it's words at this point. Ms. Ward, this is the point. You're 38 years old, and I understand something's going on because you're stealing from Walmart, and it is alleged that you're driving on a suspended or revoked license and without insurance. Now, first of all, stop that, because every time you get behind the wheel of that car, if you would have hurt somebody, you wouldn't even have the insurance to be able to make them whole.
Yeah,
So stop.
Insurance, but
No. Don't tell me nothing. Listen, because this is the whole problem we're here for. Somewhere we had a failure to communicate. So what I want you to do is to listen. I need my 40 hours of community service. I need you to go to your probation reports as directed. The bus comes right in front of this building. And so you can take MARTA to get here if you need to. I had a man walk all the way from Stockbridge to get here. Not only did he get here on time, he was healthy because he was walking. So make your way here as directed. Don't play around with me. Now, you're 38 years old. You need to get your life together. I don't care how many jobs you have to get to be able to pay for insurance, to be able to get your license back, to be able to not be stealing from the Anvil Block Walmart, but you need to get your life together. We're clear?
Clear.
All right. Because, yeah, nobody's going to hold your hand through life. Everybody got something. Everybody has something. So nobody's going to sit here and let you whine about you didn't get the message and we should have emailed you and hold your hand through the process. No, ma'am. No, ma'am. Probation is defendant driven, meaning I order you to do something, you get it done. All right. So we're going to accept your the revocation of the 7 days, give you credit for time served. You're going to return to probation. You're going to do all of your special conditions, which is essentially report and do your 40 hours of community service. And upon completion of those 40 hours of community service, then and only then may Ms. Chang talk to me about anything having to do with your case, because you got 2 more cases coming up. And guess who your judge is going to be when those 2 cases come up? Yeah, me. Every time you make a misdemeanor in Clayton County, you're coming back to me. So remember that and try not to come back to me. We're clear?
Yes.
All right. All right. So, Ms. Chang, I'm gonna go ahead and send this over, revocation of 7 days, return to probation, to complete the special conditions. Did you have any other questions, Ms. Ward? Because I don't want you confused at all.
Not at all.
All right.
Her
The
next
phone
appointment,
crack, all of that. Listen up carefully. She's giving you your next appointment.
Okay.
Ms. Ward, you need to arrive in person this Thursday, July 17th at 2 p.m.
Can you repeat that, please?
Yeah, you broke
Yes,
up a little bit,
report,
Ms. Ward.
report on Thursday, July 17th at 2 p.m.
Okay.
Thank you, Your Honor.
You're welcome.
I believe those are all the probation cases.
That's all I have, Your Honor.
All right. Thank you, Ms. Chang.
Thank you, Your Honor.
Okay, I'm sending this over. You know, I'm trying to type carefully because it'll disappear on me.
Thank you.
All right, y'all start lining them up for please.
Judge, could we, I got Miss Douglas here, OTB, but she's been waiting patiently.
I'm fine. Just tell me whoever's coming up next. Y'all don't have to make a preamble. Just bring them.
This is Miss Douglas. She has a negotiated plea. She's on the OTB calendar.
All right, let me just finish typing this and send it.
And for the state, we don't mind stipulating that there's a basis for the seating.
You know, Miss Douglas is 18. She might need to see how this works so that she's not back here before me.
Yes, Judge. Oh, I understand what you're saying. Yeah, and she did complete a risk reduction, or I'm sorry, a defensive driving course.
That's a beautiful thing. She did it too.
So that's.
And Your Honor, after Ms. Douglas, may we hear Ms. Hill, please?
May you what?
Let's just get through this one.
All right, I just sent that over. Let's see, Ms. Douglas, arraignment calendar. Jayla Iman Douglas, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
Okay, you can put your hand down. So you're before the court on State of Georgia versus Jayla Iman Douglas, 2025 CR 02791 for speeding 21 to 25 miles per hour over the limit and distracted driving. Mr. Lynch, you're representing Ms. Douglas. What does your client plead to the offenses before the court?
So the speeding, it's going to be a no contest plea, Judge. I'm not sure if you said the speed, but I know it was reduced to 65. And then the other case are going to be no pros.
All right. By entering a plea of nolo to the reduced speed on count 1, Ms. Douglas, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
Okay. Factual basis. Do y'all wanted to stipulate?
I don't have a problem stipulating there's a factual basis for speeding, Judge. I think it kind of speaks for itself.
All right. And what's the recommendation, Mr. Tipton?
Your Honor, the state has reduced the speed in our system so that it reflects that it's only going to be 20 miles instead of the 25 miles over. It is a $100 fine for the speeding plus court costs.
All right. So, Ms. Douglas, that's going to be $151.50. Are you prepared to pay that today, or do you need additional time?
I'm prepared to pay it today.
Okay, so when you go down to the second floor, you're gonna leave the courtroom, go down one floor. When you come back through the double doors, you're gonna go to your left and you'll see the traffic court, the traffic cashier office, traffic clerk cashier's office, and you'll go in there and they'll take your payment and give you your paperwork. Now, I'm sure Mr. Lynch has explained to you that between now and the time that you turn 21, this is your one-shot deal for the NOLO. So if you still out here driving like you don't have good sense, then you're going to end up getting enough points to not be able to drive. And you're going to run up the insurance on the car on whoever's paying the insurance because it's already high enough. You're 18. We clear? Let me explain. So, people who drive, and the driving is a divided attention skill. It means that you got to be able to do several things at the same time. Watch the traffic around you, watch your own speed, shift, turn, signal, all of those things. So it requires you to pay particular attention. You're 18. You have not developed the skills to be able to drive, listening to music, holding your phone, texting, talking, all of that. You will end up killing yourself or killing somebody else. We have had every year in June, in May, right around the time we have graduation, right around the time we have prom, we end up having teenagers killing each other in cars because they get so excited. They can do this, they can do that. I'm on my phone, I'm listening to this new music, I'm texting, all of that. Cut all of that out. If you want to make it to the ripe old age where you got a life of your own, kids of your own, just cut all that out. Okay? All right. Everybody thinks they can drive like it's NASCAR, but they don't understand NASCAR drivers start training when they're probably 10 or 12 on small little cars. So you don't have those skills. So don't play around with it. Get a device so that you don't have to hold your phone and you only use it in emergencies. Do you hear me? Okay. All right. So go on downstairs and pay the fines and fees. Thank you.
Yeah, you're good.
All right, who's next?
Judge, we could go ahead and do Mr. Jamantre Taylor.
Okay, Taylor.
How you doing?
I'm good. How are you, sir?
Good.
Somehow I've messed up my screen. 1 second. All right, Mr. Taylor, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. So, Mr. Taylor, you're before the court on State of Georgia versus Jamantre Taylor, 2024 CR. 10563 for obstruction of an officer, count 1, and disorderly conduct, count 2. You're represented by Attorney Owen Lynch, who's with you at the podium. Mr. Lynch, what does your client plead to the offenses before the court?
Judge, she pleads no contest to count 1. Count 2, I believe, will be null pros pursuant to the plea.
All right.
And can stipulate factual basis if
No, I want to hear this one. Mr. Taylor, by entering a plea of no low to count 1, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis, please, and I do want to hear it.
Yes, Your Honor. On December 14th of 2023, officers with the Clayton County Police Department responded to 2003 Echota, Echota Way in Riverdale, here in Clayton County. There they made contact with Mr. Jamantre Taylor and Mr. Desmaria, Desmariah, Dean, Dean. I'm sorry, that's Miss Dean. It was determined that there had been some kind of altercation where there was a fight at this house. During the investigation, they had instructed Mr. Taylor to enter a vehicle. Mr. Taylor exited the vehicle and kept approaching family members. He began yelling at the police officers, asking for badge numbers, and let's see, continued to disobey law and the police officers. State's recommendation is a $300 fine, Your Honor.
All right, Mr. Lynch.
Yes, Judge. I would have asked that you take the no low plea and accept the recommendation of the state and grant Mr. Taylor 60 days to get that paid in full.
All right, so Mr. Taylor, it's been some time. Have we resolved all these issues that put you in that situation?
Oh, yes, ma'am.
Okay, all right. So I'm going to accept your plea of no low to count 1, count 2 will be no pros. The fine is $300 with the surcharges is going to be $444. I'll give you 60 days in which to pay. Do you know how to use the chat function?
Yes.
All right, I need you to chat to Miss Amanda Wright, not to everyone, but whatever name is in blue, when you go to the chat function, click on that. It should have a pull down menu. When you click on Amanda Wright, she should be at the top of the pull down menu. Send her your email address. You want to make sure that the letters and numbers are in the correct place. And then once you do that, you'll be free to go. Please make sure you pay on or about the 60th day. You should get an email that gives you your sentencing sheet with the date by which you need to pay and information about how to pay online, by phone, or in person, okay?
Yes,
and
ma'am.
if you want to make partial payments, you can make those in person.
Okay, thank you.
All right, take care, sir. All right, so from the arraignment calendar, we still have Gwyn and Hill.
Yes, Judge. So Ms. is there a not guilty plea today, and Mr. Gwyn is ready for a negotiated plea.
All right, bring up Mr. Gwyn, not guilty from Ms. Hill. Let's see. Is Ms. Hill still in the courtroom?
He's on the Zoom call.
Oh, on Zoom. All right.
Hi, yes, I'm here. Hello.
Okay. All right, I got you.
Oh.
You never can fix your name, so I didn't even know you were here because all I'm seeing is Queen, and I don't have a Queen on my
I'm
calendar.
sorry, I tried to go and figure it out. I'm not good at this stuff.
I got you. So, Ms. Hill, please keep in touch with your attorneys. They're entering a not guilty plea on your behalf. Whatever information that they told you to bring to your next meeting, please make sure you gather that information so you're ready. If anything changes your contact information, please make sure they know how to get in touch with you.
Okay. Yes, ma'am.
All right, you're free to go at this time. Thank you.
Thank you. Bye.
Thank you. Bye.
Look at you.
Bye.
It's my daughter.
Your Honor.
All right. So Mr. Gwyn, raise your right hand for me. You solemnly swear or affirm any testimony that you give in this matter will be true.
Yes.
All right, you can put your hand down, sir. All right, so you're before the court on State of Georgia versus Rashan Gwyn, 2023 CR 00227 for speeding 31 to 34 miles per hour over the limit. You're represented by Attorney Tortorello, who's with you at the podium. So, Mr. Tortorello, what is your client plea to the offenses before the court?
It will be a guilty plea for the speeding, Your Honor.
All right, has the speed been reduced at all?
No, Your Honor.
Okay. All right, so Mr. Gwyn, by entering a plea of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right, factual basis recommendation, please.
Yes, Your Honor. On June 30th of 2022, officers with the Clayton County Police Department, while engaging in routine traffic enforcement, did observe a vehicle traveling at 77 miles per hour in a 45 mile per hour zone on Terra Boulevard near Cardinal Road here in Clayton County. It was determined that the driver of the vehicle was Mr. Rashan Gwyn, the defendant before you. State's recommendation is a $500 fine.
All right, Mr. Gwyn, the fine is $500. It'll be $737.50 with the surcharges. Did you wish to pay that today or have additional time?
Your Honor, we're requesting 60 days for payment.
All right, so Mr. Gwyn, before you leave the courthouse, I need you to go down to the second floor to the traffic court window. When you go to the second floor, when you come back in through the double doors into the hallway, you're going to go to your left. When you reach the traffic court window, they'll pull up your paperwork. The paperwork will have the day by which the payment, the fines and fees have to be paid. You can also ask about how to pay online or by phone. And if you wish to make periodic payments, you can make those in person as long as they're done on or before the 60th day, okay? All right, so Mr. Gwyn, don't wait till the last minute to pay it. There's a lot of people, I give them 60 days to pay, and they say, oh, I'm gonna do it, and then they forget, and then an arrest warrant will issue. So you don't want that.
Definitely don't want it.
All right, and slow down, Mr. Gwyn. It's gonna be there when you get there. Leave a little early, okay?
Yes, ma'am.
I know everybody got a Challenger, a Charger, something with a Hemi, and they just don't know how to act on the roads now.
Not me. That was a truck that wouldn't even get up to that speed limit, but I just accept, I accept whatever they say, I guess.
All right, Mr. Gwyn, take care.
You too.
Excuse me, Judge, what was the fine amount?
It's $500.
Thank you.
All right, and he's got 60 days to pay. All right, so that concludes the arraignment calendar. Let's get moving on the jail calendar.
Your Honor,
So, yes,
we're ready with Miss Tiffany Chambers.
okay.
they're actually signed up for plea.
Ms. Chambers, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. Okay, is the courtroom muted? Oh, no, it's not. Speak up, Ms. Chambers, for me. All right, so this is case 2025 CR 06082 for criminal trespass, count 1, loitering or prowling, count 2, drug-related object, count 3. Ms. MJ Tortorello is your attorney, Ms. Chambers. Ms. Tortorello, what is Ms. Chambers' plea to the offenses before the court?
Your Honor, for count 1, criminal trespass, there'll be a no-low plea.
Okay.
Count 3, a drug-related object, that's a no-low plea. And then count 2, loitering, my understanding is that charge will be no pros.
All right. By entering a plea of no load to counts 1 and 3, count 2 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, Ms. Chambers?
Yes, Your Honor.
All right. Facts, factual basis and recommendation, please.
Yes, Your Honor. Your Honor, on June 20th of 2025, officers with the Riverdale Police Department responded to 6476 Voiles, that's V as in Victor, OYLES Drive in Riverdale, here in Clayton County, in response to a breaking and entering. It was determined that the defendant before you, Ms. Chambers, did attempt to pick a lock and enter into a residence unsuccessfully. And upon stopping her, they found a glass pipe commonly used for the introduction of crack cocaine to on her person. No crack cocaine found on her person. State's recommendation, Your Honor, for count 1 is 12 months to serve 30 days. Balance suspended upon do not return to the incident location. That is 6476 Voiles Drive. Count 2 will be null pros. Count 3 will be concurrent time. Nothing further from the state.
All right. Anything, Ms. Tortorello?
Only that Your Honor would accept the plea as negotiated.
All right. Counts 1 and 3 will run concurrently. Same sentence, 12 months to serve 30 days. Credit for time served. Balance will be suspended as long as you do not go back to 6416 Voiles Drive in the municipality located in Clayton County, Georgia. All right. Ms. Chambers, if you need help transitioning back out of jail, ask to speak to a chaplain. They may have information that could help you, okay?
Yes, ma'am.
All right, thank you.
Thank you, Your Honor.
All right, who's next?
All right. Your Honor, we are ready for Joseph Johnson.
Okay.
Mr. Joseph Johnson. You're welcome.
All right, raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true?
Yeah.
All right, you can put your hand down, Mr. Johnson. You're before the court on state of Georgia versus Joseph Keith Johnson, 2025 CR 06151. Count 1, simple battery family violence. Count 2, simple battery family violence. Count 3, criminal trespass. Ms. Tortorella, what is your client plead to the offenses before the court?
Your Honor, per my understanding, it's count 1 is simple assault family violence.
Oh, I'm sorry. It cuts it off on my calendar. Simple assault family violence. What's the second one?
Same charge, Your Honor, simple assault family violence, and then criminal trespass. My understanding, Your Honor, simple assault family violence for count 1 will be reduced to simple assault. He will be pleading nolo to that reduced charge. Simple assault family violence count 2 will be reduced to simple assault. Will be pleading nolo, and count 3 criminal trespass will also be a nolo plea.
Okay. All right. So the charges are being amended to count 1 simple assault, count 2 simple assault, no family violence designation on either, and criminal trespass. He's entering a nolo plea to counts 1, 2, and 3. By doing so, Mr. Joseph Johnson, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. You understand all of these things, sir?
Yes, I do.
Okay. Factual basis and recommendation, please.
Thank you, Your Honor. Your Honor, on June 13th of 2025, officers with the Clayton County Police Department responded to a family violence call at 939 Vinton, V as in Victor, INTON Woods Drive in Forest Park. There they made contact with Mr. Rodney, common spelling Lewis, Lewis. Mr. Lewis advised that the defendant before you, Mr. Joseph Johnson, did kick in the door of the residence and then attempted to commit a battery that he was not successful at by swinging his arms at Mr. Lewis and Mr. Lewis's wife, Lachelle. That's Lachelle. Your Honor, the facts do not indicate that Mr. Johnson had previously lived with Miss Lewis, although he is a sibling of Miss Lewis, there is no direct evidence that they did live together previously. The state's recommendation, Your Honor, for count 1 is 12 months to serve 21 days, credit for time served, balance probated, anger management, a $300 fine. Count 2 will be concurrent time with count 1.
All right, so is Mr. Johnson capable of completing probation successfully? A $300 fine is going to be $444. Even over 12 months for somebody with no means, is that doable? An anger management class is going to require him to sign up for, complete, maybe possibly have an electronic device, a digital device. Is this a possible sentence that he can complete successfully?
My client says that he can complete this successfully.
Has he been on probation before, Mr. Tipton?
Yes, Your Honor, it appears he has been on probation previously. This will be his eighth cycle in Georgia, Your Honor. It appears that he had previously been placed on probation. Excuse me, Your Honor, the last time it looked like the last two sentences were suspended sentences.
Okay.
And let me see. He was previously on probation out of DeKalb County, but that was in 2022. I don't know if that was successful or not.
All right. Yeah, because I hate to judge, but just looking at Mr. Johnson and these charges, I don't get that there's stability here. Successful probation, as we have just seen today, requires stability. And Mr. Johnson will definitely be kept away from the Forest Park address and from Mr. Lewis, but can he do the anger management class? Can he pay the fine of $300? I just don't see that happening.
Your Honor, at this point, the state's going to instead, if I may have one moment with defense counsel.
Yeah, y'all talk about this, because I'm not going to set him up for failure.
Your Honor, state has an update offer. State's going to suspend the balance. Do not return, no contact.
Yeah, that sounds good. Thank you. All right. So yeah, I just don't think that it was going to work with him not having means and then having to be punished for something I already know is not going to make sense. So Mr. Johnson, 12 months to serve 21 days, credit since the date of lockup, credit for time served. Your balance will be suspended as long as you have no contact with Rodney Lewis, and that you do not go back to 929 Venton, VENTON Woods Drive in Forest Park, Georgia, Clayton County. Now, Mr. Johnson, this is concurrent for all three sentences, count 1, count 2, and count 3. Listen to me carefully, Mr. Johnson. If you go back to Mr. Rodney Lewis's house, you could be arrested again and charged with felonies. You understand? Do not go back to Mr. Rodney Lewis's house. For 12 months, you do not go back to Mr. Rodney Lewis's house. Okay. Do you understand? Speak it to me. I'm not just nod your head.
Yes, I understand.
Okay. If you need help transitioning from the jail to outside, ask to speak to a chaplain if you can before you leave the jail, okay? They may have information that can help you. All right? All right. Take care of yourself, sir. All right. Who's next?
Your Honor, I'm ready for Mr. Patrick Jones.
Okay.
Did you want to come to my office with Mr. Lynch later and go over the trial calendars and the Get inside, there we go. Stay right here. You are President Jones, where is he?
Yeah, second.
All right, who's this gentleman?
This is Mr. Patrick Jones, Your Honor.
All right, Mr. Jones. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. So this is 2025 CR 06074 for DUI less safe, count 1, improper lane change, count 2. You're represented by attorney MJ Tortorello. Ms. Tortorello, what is your client plea to the offenses before the court?
It will be a guilty plea on both counts, Your Honor.
All right, by entering a plea of guilty to counts 1 and 2, Mr. Jones, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or not incriminate yourself or present any evidence or testimony against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
Factual basis and recommendation, please.
Yes, Your Honor. On May 31st of 2025, officers with the Clayton County Police Department responded to a vehicle accident that was located near 2693 Jodico Drive. It was determined that the defendant before you, Mr. Jones, while driving his in his lane, which caused a single vehicle accident. While they were speaking with Mr. Jones, they could detect a strong odor of alcohol coming from his person. They observed that he had difficulty maintaining his balance and walking, and they proceeded to standardized field sobriety tests, which Mr. Jones agreed to. The results of the standardized field sobriety tests were that Mr. Jones demonstrated 6 out of 6 on HGN, 4 out of 8 on walk and turn, 2 out of 4 on one leg stand. Implied consent was read, but Mr. Jones refused. State's recommendation, Your Honor, for count 1 is 12 months to serve 45 days, credit for time served, balance probated, a $300 fine, 40 hours of community service, a substance abuse evaluation, any recommended treatment, no drugs or alcohol subject to random testing, a DUI risk reduction course, a $300 fine, and count 2 is a fine of $100.
I'm sorry, what was count 2?
A suspended fine of $200, Your Honor.
All right, Ms. Tortorello.
Yes, Your Honor. Defense only asks that you accept the plea as negotiated.
All right, Mr. Jones, the fact that you had an accident while impaired, it is just fortunate that you didn't kill yourself or kill somebody else. I'm sure you caused them a certain amount of like mental pain, if not physical pain, because nobody expects to get hit or get into an accident, and the damage to the vehicle and all of those things that come with that. But sir, you don't have the right to hurt someone else because you make the choice to drive impaired. We have Lyft, we have Uber. There are so many options that you have to not do that, that to do so is intentional. If you did get behind the wheel of a car under the influence of alcohol, you are making an intentional decision. Whatever flows from that decision, whether you die, whether somebody else dies, whether somebody gets hurt, whether they have no property, whether you deprive them of the ability to get to work every day, all of those consequences are because you made an intentional choice to get behind the wheel of a car impaired. Are we clear? So be prepared to accept all of those circumstances. You don't have the right to put somebody else in that situation. I'm going to accept your plea of guilty to counts 1 and 2. On count 1, I'll sentence you to 12 months to serve 45 days. Balance will be probated for you to pay a fine in the amount of $300. It's going to be an enhanced fine, so it's probably going to be closer to $700 or $800. You'll do 40 hours of community service, substance abuse evaluation, and any treatment that might be ordered. You're also going to take a risk reduction course. You'll have no alcohol or illicit drugs during the course of your probation. You're subject to random screens for alcohol and drugs. You're on count 2, which will run concurrent with count 1. It's a $200 suspended fine, okay? You're going to meet with probation. What I need to tell you, absolutely, because people have been telling me they didn't get the message. You need to do everything I am ordering you to do. You need to make sure you go to your probation reports. If you don't hear from them, then you contact them. You're going to meet with the probation intake officer. She's going to give you that information that you'll need to successfully complete probation. But the quickest way to get back here is to mess up is to fail to report to probation. Do you understand me? All right. And people don't think we randomly screen. We do, and we catch people. So please be mindful of that also.
And
All
Your
right.
Honor, just for the record, that's credit for time served on his sentencing, correct?
If that's what y'all agreed to, that's fine.
Yes, Your Honor, it's 45 credit for time served.
And Your Honor, that is what we agreed.
Okay, credit for time served. All right. All right, Mr. Joe.
Oh, and Your Honor, just wanted to, something else on behalf of my client. He's on hold here on parole. He has 6 more days. If probation can start maybe after the 6th day.
I'm sorry, he's on parole.
Yeah, he has 6 more days left. He's on hold here on parole.
Okay, it doesn't start until he gets out of jail anyway, but he's still going to meet with the probation intake officer. Okay. All right. So according to my list, I have Jenkins, Kinsley, Rigby, Shavers, Smith, Walker, and Wright left. So let's bring them on forward.
I'm ready for Rigby, Your Honor, Mr. Melvin Rigby.
All right.
And Mr. Thorp can be, I see he's still on there for a minute.
Yeah, Mr. Thorp, you're free to go at this time. Just keep in touch with your attorney and do what she's asking you to do.
Your Honor, this is Mr. Melvin Rigby.
All right, Mr. Rigby, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, Your Honor.
All right, you can put your hand down. So Mr. Melvin Rigby Jr., 2025 CR 06150. You're before the court for obstruction of an officer and criminal trespass. You're represented by attorney MJ Tortorello. Ms. Tortorello, what is your client plea to the offenses before the court?
Your Honor, my client's only pleading to count 2 criminal trespass. That would be a nolo plea. My understanding is that obstruction will be no prost.
All right, by entering a plea of nolo to count 2, Mr. Rigby, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right, factual basis of recommendation, please.
Your Honor, on May 25th of 2025, officers with the Clayton County, especially with the Morrow Police Department, responded to 351 Jonesboro Road in Morrow here in Clayton County. There they were able to determine that the defendant before you, Mr. Rigby, entered upon that premises after being told that he was not to return to that premises. Your Honor, state's recommendation is 12 months to serve 20 days, balance suspended, credit for time served. Do not return to the incident location.
All right, who lives at that location, or what is his connection to it?
Your Honor, that's the Cuff Link Real Estate Building. Let's see, which is a business.
It's a vacant business, Your Honor.
Okay. All right, so Mr. Rigby, I'm going to accept your plea to count 2, nolo, count 1 will be no prost. I'll sentence you to 12 months to serve 20 days, credit for time served. Ballots will be suspended as long as you do not go back to the incident location. If you were to go back, sir, you could be rearrested. You could be charged with additional misdemeanors or felonies. Do you understand?
Yes, Your Honor.
All right, you can go back with the sheriff's office.
Miss, I'm ready for Mr. Edward Smith, Your Honor.
All right.
So we're gonna Smith next.
Hey, bro, you get Smith for me. Yeah. About to see you guys. That was Rigby, right? Yes, yes, sir. Almost said yes, ma'am, because I've been talking to her all day. It's all good. I'm gonna take no time away.
Raise your right hand, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, you can put your hand down. This is Mr. Edward Maurice Smith.
Yes, Your Honor.
Mr. Smith, you're before the court on 2025 CR 06077 for obstruction of an officer and theft by shoplifting. Ms. Tortorello is your attorney. Ms. Tortorello, what is your client plead to the offenses before the court?
For count 1, Your Honor, will be a nolo, and count 2, theft by shoplifting, will be a guilty plea.
All right, Mr. Smith, by entering a plea of nolo to count 1 and guilty to count 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
Factual basis recommendation, please.
Yes, Your Honor. Your Honor, at on September 8th of 2023, officers with Riverdale Police Department responded to 7050 Highway 85. That is the Riverdale Walmart, in response to a loss prevention call. It was determined that the defendant before you, Mr. Smith, passed all points of sale with merchandise belonging that folding knives that he had tucked into his waistline. Let's see. While this occurred, he did attempt to run from one of the officers, specifically Lieutenant C. Cooper with the Riverdale Police Department. Your Honor, the state's recommendation is 12 months to serve, credit for time served on count 1. Count 2 will be concurrent time. Mr. Smith has been incarcerated continuously on a felony since 2023.
In no-go Walmart?
Your Honor, it's just 12 months to serve. Mr. Smith has been in for more than 12 months.
Okay. All right, Mr. Smith, I'm going to accept your plea of no load to count 1, guilty to count 2, 12 months credit for time served, concurrent on counts 1 and 2. The balance will be suspended as long as you have no new violations of the laws of the state of Georgia. Mr. Smith, everybody steals from the Riverdale Walmart. It is the most stolen from Walmart probably in the state of Georgia. Sir, they catch everybody. Some they prosecute, some they don't. But you're not going to get away with stealing from the Riverdale Walmart.
Yes, Your Honor.
Because they know everybody steals from the Riverdale. So don't do that again. You can go back with the sheriff's officer.
Thank you, Your Honor.
All right.
Can y'all bring out, I got more than that.
We got 6.
Sorry, Judge, what was that?
We got 6 left.
Yep. If I can. Let's do Mr. Jenkins. Can we get Anthony Jenkins, please? You laughing at me?
Stand by him.
All right, raise your right hand, Mr. Jenkins. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yeah, ma'am.
All right, you can put your hand down, Mr. Jenkins. You're before the court on state of Georgia versus Anthony Quinn Jenkins, 2025 CR 06205 for driving on a suspended or revoked license and no license. Mr. Owen Lynch is with you at the podium. He's your attorney. Mr. Lynch, what is your client, Mr. Jenkins, plead to the offenses before the court?
Judge, he'll plead no contest to count one. We will stipulate to a factual basis. I believe count two will be null pros.
All right, by entering a plea of nolo to count one, you give up the right to have the trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony, to not incriminate yourself or present evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yeah.
All right. Factual basis recommendation, please.
Your Honor,
I'm sorry, you stipulated, so recommendation, please.
It's suspend $1,000, 12 months to serve, 120 days, credit for time served, balance suspended. It's my understanding Mr. Jenkins has been in on these for 120 days, and he has, I think he's in on some additional charges that have yet to matriculate.
So he wasn't there for us. He just getting credit for the time. All right. So Mr. Jenkins, I'll accept that. I'll accept your plea of nolo to count one. Count two will be no prost. 120 days credit for time served. Balance will be suspended. $1,000 fine will be suspended for credit for time served. All right. You can go back with the sheriff's office.
And Your Honor, Mr. Kamani Walker is a not guilty plea. I'm not sure if you got that.
No, I didn't hear anybody announce for Walker. Walker's not guilty, can go back with the sheriff's office. You gave Walker the speech?
Yes, Judge.
All right, so no one on behalf of Walker is to contact the alleged victim or victims in this case. There's to be no social media contact. There's to be no contact through any other individual. There's to be no contact on behalf of Mr. Walker with that individual at all, or that will be considered contact from Mr. Walker and a violation of his bond conditions. Please do not help Mr. Walker violate bond conditions. All right, who's next?
Judge, this is Mr. Wright, Quan Wright.
Mr. Wright, raise your right hand for me. You solemnly swear, raise your right hand for me. Other hand. You solemnly swear or affirm any testimony you give in this matter will be true. Mr. Wright.
She's asking, you gotta listen and respond. She's asking you if you solemnly
Do
swear.
you understand that you're entering a plea? You're giving up the right to go to trial because you're going to enter a plea here today. You're not going to get to tell your side of the story or present evidence against yourself. And if you're not a United States citizen, the plea that you enter today could have an effect on your citizenship. Do you understand that?
Yeah, speak up. He indicated yes, Your Honor. You need to speak.
Okay. All right, you can put your hand down, sir. Any concerns, Mr. Lynch?
No, Judge, I do not have any concerns as to Mr. Wright's competency to enter a plea today. He does understand the basis of the charge for criminal trespass. He understands his right to a trial, and he understands the recommended sentence. And I'm gonna suggest that he is, yes, I don't have any concerns as to his competency, Judge.
All right, Mr. Wright, you can put your hand down. All right, so you're before the court on 2025 CR 06155 for criminal trespass. Miss, what does your client plead to the offense before the court?
No contest, Judge. This is an airport case.
All right, so Mr. Wright, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. And by entering a plea, you give up the right, you understand that this could have a negative effect on your immigration status, and you understand all of those things. All right, factual basis and recommendation, please.
Yes, Your Honor. Your Honor, this is a case of airport trespass. The defendant was instructed not to return to the premises of Hartsfield-Jackson International Airport without a ticket to fly. He did in fact return to the Hartsfield-Jackson International Airport after being given notice not to return. State's recommendation is 12 months to serve 25 days, credit for time served, do not return without a ticket to fly, balance suspended.
All right, so Mr. Wright, do not go back to the airport, sir. I'm going to accept your plea of nolo, send you to 12 months to serve 25 days and give you credit for the time served. Balance will be suspended as long as you do not go back to Hartsfield-Jackson Atlanta International Airport. Do you understand? All right, don't go back to the airport, sir. All right, you can go back with the sheriff.
I'll get up.
Sir.
All right, the last two cases I have are Kinsley and Shavers.
Yes, Judge. Can we get Kinsley next?
All right, Mr. Kinsley, raise your right hand for me.
Hi. Hi.
Hi.
She asked you to raise your right hand. Oh, I'm bad. I'm sorry.
That's okay. Do you solemnly swear or affirm any testimony you give in this matter will be true? Or are you going to tell the truth for me?
Yes, ma'am.
All right, you can put your hand down. All right, you're before the court on State of Georgia versus Joseph Healy Kinsley, 2025 CR 06083 for criminal trespass. You're represented by attorney Owen Lynch, who's with you at the podium. Mr. Lynch, what is your client plead to this offense?
No contest, Your Honor.
All right, Mr. Kinsley, by entering a no contest or a nolo plea, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself or present evidence and testimony against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor.
All right, factual basis and recommendation for Mr. Kinsley.
Your Honor, on June 18th of 2025, with the Clayton County Police Department to 5290 Riverdale Road in Atlanta, in a portion of Atlanta that is within the boundaries of Clayton County. That is the location of Prime Pizza. It was determined that the defendant before you, Mr. Kinsley, was a prior employee of the establishment and was told not to return. However, he returned to get, and when police arrived, he was present and stated he had returned to give the clerk a candy bar. The state's recommendation, Your Honor, is 12 months to serve 26 days, credit for time served, balance suspended upon do not return for any reason.
All right, Mr. Lynch?
I would ask the court accept that recommendation. Mr. Kinsley understands that he is barred from returning to that location both by this sentence and by the previous criminal trespass warning.
All right, Mr. Kinsley, I'm going to accept your NOLO plea. You've been given a criminal trespass warning, but this sentence means that if you were to go back to that location, you could get additional misdemeanors charged against you, and you could be returned to court for the balance of the sentence and face jail time. You understand?
Yes.
Okay. So 12 months to serve, 26 days, credit for time served, balance suspended as long as you do not go back to that location, okay?
Yes, Your Honor.
All right, take care of yourself. If you need any help transitioning out of the jail, ask a chaplain. They may have information that could help you.
Thank you.
All right, take care.
Shavers should be the last one.
Shavers?
Yep. I think he's coming up for a plea.
And Your Honor, my computer has died. May I address my staff real quick?
Yes.
Okay. Ms. Hemphill, Investigator Robinson, Ms. Arnold, if any of you were waiting to go on lunch, please feel free to go ahead. Unfortunately, my computer died, so I couldn't give you guys a Teams message.
No problem. All right.
We got one more. Stand right next to me.
All right, Mr. Shaver, Earl Shavers.
Yes, ma'am.
All right, raise your right hand for me, Mr. Shavers. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you put your hand down. Mr. Shavers, you're before the court on 2025 CR 06158 for theft by shoplifting. You're represented by Attorney Owen Lynch, who's with you at the podium. Mr. Lynch, what is your client plead to the offense before the court?
Judge, she's going to plead guilty today.
All right. Mr. Shavers, by entering a plea of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis recommendation, please.
Yes, Your Honor. Your Honor, on June 24th of 2025, officers with the Clayton County Police Department responded to the Walmart located at 2940 Anvil Block Road in Ellenwood, Georgia, here in Clayton County. It was determined that the defendant before you, Mr. Shavers, did in fact leave Walmart while without scanning for all of his items.
All right.
Yes, Your Honor. He passed all points of sale, and the total amount of merchandise that was stolen was in the amount of $54.48. State's recommendation, Your Honor, is 12 months to serve 30 days. Balance probated. Do not return to any Walmart in Clayton County. $500 fine. 80 hours of community service and an anti-shoplifting class. This will be Mr. Shavers' third in line shoplifting. And I have been assured by defense counsel that Mr. Shavers will be able to complete this probation.
All right. Mr. Shavers, what is your fascination with getting the stuff for the low?
I have no fascination, Your Honor.
Well, Mr. Shavers, I can count on one hand the number of people I know who routinely steal from Walmart. You at the top of my list. So why are we stealing at all? Why are we shoplifting? Let's go basic. How old are you, sir?
To rescan and
No, don't do it. Because first of all, I don't understand why people think those machines aren't smart. Those are the smartest machines they make. Because while you are skip scanning or not scanning, they're watching you. There are cameras embedded under the lasers. So they are watching you while you think they're not. You think because the overhead camera's not watching you, but there are cameras in the machine. So all of that stuff about, no, sir. So now let's get down to brass tacks. How old are you?
I'm 59.
Okay, so you're almost 60 years old. My husband used to say, in fact, he still says it, if you are doing the same thing at 60 that you were doing at 20, you have wasted 40 years of your life. What is your plan, sir?
In life or what you mean?
Yeah, because you can't keep coming back here in an orange jumpsuit. Them young guns back there in that jail are crazy, which means that OG, if you keep coming back there, you're gonna be a victim.
No, I'm not coming back.
No, that's what you said the last time and the last time and the last time. We're up to our third shoplifting charge. What I need you to do is figure out what's going on in your life and see where we went wrong. Is it drugs? Is it alcohol?
Yes, ma'am.
Okay, so you need a program. Get some information for the Salvation Army. They may have a program that can help you. If nothing else, the community support groups such as Alcoholics Anonymous, Narcotics Anonymous are free and readily available. Start going to one of those. Start talking through whatever this issue is. Because at 69 years old, the shoplifting, the alcoholism or the drugs, you do not want to be in the Clayton County Jail or any other jail at 70 years old. That's not a good look for you, sir.
Yes, ma'am. I did that, ma'am. I'm in the jail.
Yeah, but you need to continue to do it. It's not a one-shot deal. It's not like I took my medicine, I'm finished. No, you don't cure alcoholism. It is an ongoing thing. And when you don't understand that, that's why you end up back here. And so what I'm saying to you is I will be seeing you or have the potential to see you periodically over the course of the next 12 months because your sentence is 12 months to serve 30 days balance probated for you to pay a fine in the amount of $500. That's going to be $737.50. Now, somebody who has 3 shoplifting charges, I don't really think you're going to be able to pay the $737.50. I might be wrong, but you agreed to this sentence, but I have my doubts. Then there's 80 hours of community service. You need to do those 80 hours of community service. Do some good for somebody else and help yourself at the same time. An anti-shoplifting class. You're going to have to pay for that. And you're not to go back to any Walmart in Clayton County, any of them. No Walmart within the confines of Clayton County, Georgia. Are we clear?
Yes, ma'am. I can.
Don't tell me what you can do. Show me.
Yes.
Don't tell me what you can do. Show me. Now, the quickest way to get rearrested and come back to court is to not appear for your probation reports. You start missing probation reports, you're going to come back to me in an orange jumpsuit. And like I said, you're 69 years old. 59 years old. That's not a good look for you. Them young guns in that jail, they not playing. So get yourself together.
I understand, ma'am. I can agree. I could pay the fine, but I don't think I can do all that community service because I can't walk.
I think you can. Why can't you? Why can't you?
I can do it, ma'am.
Yeah. Stop telling yourself what you can't do. That's how you ended up here.
I just have injuries. I just know that I have.
Well, then find something that you don't have to do injuries. You can sit and do phone banks for some organization. There are alternatives,
Okay. I
but
understand.
don't tell me what you can't do. Tell me, I'm gonna get it done, Judge.
I'm gonna get it done, Judge.
All right. I'm gonna see you again, because I know this conversation ain't gonna resonate with you, and you're gonna be back here on some foolishness. But we'll see. I'm gonna hold out hope that you are gonna get it done. All right. You're gonna talk to probation, do your intake, and do not miss your reports.
Yeah, ma'am.
All right. Take care, sir.
Here, man, they have a little confidence in me. I'm gonna do it.
All right. That's what I want, sir.
Yes, ma'am.
You can't live this life always thinking what you can't do. All right. Take
Right.
care.